ಹೇಳಿ ಸರ್. ಹಲೋ, ಹೇಳಿ ಸರ್, ಹೇಳಿ 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 ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ, ಹೇಳಿ ಸರ್, ಹೇಳಿ. ಏನು ಮನೆನಾ? ಮನೆ? ಹಾ, ಸರಿ. ಹಾ ಹಾ ಸರಿ, ಆಯ್ತು. ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು. ಸರಿ ಸರಿ, ಓಕೆ ಸರ್.
ನೋಡಿದ ಏನ್ ಬೇಕಾ?
ಸರ್ ಟೋಟಲ್ 16 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ. ಓಕೆ ಸರ್.
ನಿಮ್ಗೆ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಮೇಡಮ್ ಇದಕ್ಕೆ ಎಲ್ಲದಕ್ಕೂ 1 to 58 ಅಲ್ಲ, 1 to 55. So which time is granted to do the needful.
Court officer.
Yes, sir.
Sir, serial second list. Hello. Hello. Court officer. Court officer. Court officer. ನಾಗರಾಜ್ ಅವರೇ,
ಹಾ
ಇದು ಕೋರ್ಟ್ ನಂಬರ್ 16 ಅಲ್ವಾ?
ಹೌದು, ನಾವು ಪೋರ್ಟಲ್ ನಂಬರ್ 16 ಅಲ್ಲೇ ಕೂತಿದ್ದೀವಿ.
ಸರಿ ಸರಿ ಸರಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಸರ್, second is serial number 22.
ಹಾ,
It is connected with 1012 of 20 ANK ಪೇರ್ ಆಗ್ತಾರೆ ಇದರಲ್ಲಿ.
already connected with
1012/20
1012/20.
ANK.
ಸರಿ ಸರ್, ಸಾಹೇಬ್ರಿಗೆ ಒಂದು ಮಾತು ಹೇಳಿ.
ಸರಿ ಸರಿ, ನಾ ಹೇಳ್ತೇನೆ. ಸಪೋಸ್ ಒಂದೊಮ್ಮೆ ನಾನು 31 ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರೆ ಅಂತ ಫಸ್ಟ್ ಹೇಳ್ಕೊಂಡ್ಬಿಟ್ಟೆ.
ಆಗ್ಲಿ ಸರ್.
ಸರಿ ಸರಿ.
ಹಲೋ, ಎಲ್ಲಿದೆ? ಅಂತ ಹೆಸರಿನಾಗೈತೆ. ಮಿರರ್ ಪಕ್ಕದಲ್ಲೇ ಐತೆ, ಕಾಣಿಸ್ತಾ ಇದೆಯಾ? ಅದ್ರ ಒಳಗಡೆ ಮಿರರ್ ಪಕ್ಕದಲ್ಲೇ ಹೋಗ್ಬೇಕು.
ಹೂನಪ್ಪ, ಅದ್ರಲ್ಲಿ ಇದೆ ರೀ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರು. ಬನ್ರಿ ಇಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಬುದ್ಧಿ ಉಪಯೋಗಿಸ್ಬೇಕು ನೀವು. ಅಲ್ಲಿ ಫುಲ್ ಪೂರ್ತಿ ಹುಡುಕ್ರೆ ನೋಡಪ್ಪ 769 730 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಜಡ್ಜ್ಮೆಂಟ್ ತೆಗೆದಾಗ ನೀವು ಇದ್ರಲ್ಲಿ
ಶಿವಕುಮಾರ್ ಎಲ್ಲಾರ್ಗು ಕೇಳಿಸ್ತಾ ಇದೆ ನಿಮ್ಮ ಆಫೀಸ್ ವ್ಯವಹಾರ. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅವರೇ ಹೇಳ್ಕೊಂಡ್ರಿ ವೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಸಾಹೇಬ್ರಿಗೆ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಣಿಸ್ತಾರೆ, ವಿಡಿಯೋ ಇಲ್ಲ. ಇಲ್ಲಿ ಬರುತ್ತೆ, ಅದು ಅಲ್ಲಿ ಸ್ಟೆಪ್ ಆಗಿದೆ. ಇವಾಗ Ladies and gentlemen, page number 2, page number 1, serial number 1 to 3, page number 2, serial number 4 to 9, page number 3, serial number 10 to 13, page number 4, serial number 14 to 17, page number 5, serial number 18 to 21, page number 6, serial number 22 to 25, page number 7, serial number 26 to 31.
Sorry, man. Serial number 22. Serial number 22.
22. Yes.
ಇದು ಏನಕ್ಕೆ ಒಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ 1012 of 20. I have already furnished the number to the court officer.
Number ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕರೆದ್ರೆ ಅದ್ರಲ್ಲಿ ಒಂದು IA ಪೆಂಡಿಂಗ್ ಇತ್ತು. ಮತ್ತೆ ಈ IA ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅದು ಅದ್ರ ಬೈ ಮಿಸ್ಟೇಕ್ ಇದ್ರಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೇನೆ ಅದ್ರಲ್ಲೂ
ಪೇಜ್ ನಂಬರ್ 7 serial number 26 to 31, page number 8 serial number 32 to 37, page number 9 serial number 38 to 41.
My lord, serial number 39, my lord, appear for respondent in this case. Kindly have it next week, my lord.
Yes, at the request of counsel for R1, relates this matter to serial number. Yes. PCR to the office is directed to secure original records from the tribunal. Page number 10. Yes, 41. ಇನ್ನೊಂದಿದೆಯಾ? The net counsel for appellant has submitted this matter may be called along with the phone. Page number 10, serial number 42 and 43. Page number 11, serial number 44 to 47.
Serial number 44, my lord. Kindly be LCR, kindly be called from. Serial number 44, my lord.
44, your yes.
Chandrasekhar appearing on behalf of the appellant.
Office is directed to secure original records from the tribunal.
Much obliged.
46, office is directed to secure original records from the tribunal. Page number 12, serial number 48 to 55. ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರು? R2, Exam Mukund is directed to take notice for respondent number 2. The net counsel for the appellant submits that this appeal may be called along with its own. Page number 13, serial number 56 to 60. Page number 14, serial number 61 to 65.
63, my lord. Serial number 63 may be taken after the 27th or 28th. 27th or 28th.
62, at the request of counsel for the appellant.
63, my lord.
63, at the request of counsel for R3.
27th or 28th.
My lord, serial number 65, my lord.
65, yes.
Respondent. I am for the respondent, my lord. Press which time, my lord?
Release this matter of 2 weeks. Yes. Page number 15, serial number 66 and 67. Wait. 65 ಅಲ್ಲಿ
Please, my lord.
65.3 ಏನ್ರಿ ಅದು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ ಆಫ್ ಆಫೀಸ್
ಅದು
ಅಬ್ಜೆಕ್ಷನ್
ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ. My lord, ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 2 ಪೇಜ್ ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಾಪಿನಲ್ಲಿ 2 ಪೇಜ್ ನ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ, ಕಂಟಿನ್ಯೂಷನ್ ಇಲ್ಲ. ಅದು there is a main objection, my lord.
yes you comply that
Please, my lord. I have the certified copy and then complaint.
really week's time is granted to comply that also.
Please, my lord.
Number 1, orders regarding publishing of the secretary and respect of respondent, serial number 1 to 55. Yes. 49. Is MFA 1189. Please, sir. Yes. Dispensation, you file it in the office. It will put up, then we will pass an order. Yes, is there any counsel for Janardhan Reddy is there? For which respondent? Huh? Respondent number? Janardhan Reddy is directed to take notice for respondent number 2. Notice to R1 is dispensed. Yes. 40, 45 and 48. 45. Gita Raja has filed an wakalat. Yes. Lokadalat. R1 no. Notice to R1 is dispensed. 45. At the request, refer the matter to Lokadalat. Innond yado. 48. 48 also said. Yes. You are withdrawing.
Serial number 8.
39. Bernard Council. Huh? Yes, that will permit it to withdraw. Bernard Council for the appellant has filed a memo dated 10/6/2022 seeking leave of this court to withdraw this appeal on the ground that the matter has been settled out of court. The memo is taken on record. The above appeal is dismissed as withdrawn. The office is directed to refund that statutory deposit in favor of the appellant after due verification. 50, 53. Furnishing a PF. Now that you dispensation, you file it. Here is there a counsel? Yes. Which respondent? Shivanagoda is directed to take notice for respondent number 1. Notice to R2 is dispensed. At the request of counsel for the appellant, refer this matter to Lokadalat. Interlocate the application matter, serial number 56 to 58. 56. Huh? Is it climax appeal? The learned counsel for the appellant has filed a memo seeking permission to withdraw that appeal. The memo is taken on record. The above appeal is dismissed as withdrawn.
List number 1, process matters were there.
Yes, process matter we have granted time 2 weeks.
2 weeks, my lord. Much.
Matter 2 weeks.
Much.
66. Awaiting service of notice. Then concerned awaiting service of notice.
I appear for appellant. Await TCR ಅಂತಿದೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಆಗಿತ್ತು.
Yes, await TCR. Yes. Non-compliance of the office objection. Week's time is granted to comply the office objection. Awaiting service of notice to R1 and R2. Steps to be taken for R to uncover the professional of the press. 2 weeks time is granted to do the needful. Yes. R2 postal Sarah has no data found. Yes. Shivanagoda is directed to take notice for respondent number 2. R1 again. Yes, filed in a memo seeking dispensation of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. There our appeal idya. Innond idya. The net counsel for the appellant submits that this appeal may be called along with that. So on. Yes, United India Insurance Company, are there? Janardhan Reddy. R1 is served unrepresented. Janardhan Reddy is directed to take notice for respondent number 1. The net counsel for the appellant has filed a memo
seeking dispensation of service of notice to R2. Memo is taken on record. Notice to R2 is dispensed at the request of appellant.
Number 8, yes, Raju for appellate.
Regarding to the legible type copy of the judgment award, yes. Attack ಹಾಕಿದ್ದಾರೆ. Yes. Submission of the counsel is accepted after objection is overruled. ಅದೊಂದೇನಾ? Issue notice. Yes, ready. Yes, yes, Mr. Raghu. What is 2019? ಇಲ್ಲ. 10,000 ತಗೊಂಡಿದ್ದಾರಾ? 2019 ಅಲ್ವಾ? 14,000. ಬಾಕಿದೆಲ್ಲ ಫ್ಯೂಚರ್ ಟ್ರಾನ್ಸ್ಫರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರಾ? %40. What is his age? 38 years. Multiplier 15. 40 consortium. General expenses. Class of estate ಕೊಟ್ಟಿಲ್ವಾ? ಎಸ್ಟೇಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ? ಇನ್ನೇನಿದೆ? ಇನ್ಯಾವ ಗ್ರೌಂಡ್? ಓನ್ಲಿ ಇನ್ಕಮ್. ಕನ್ವೆನ್ಷನ್. Raghu, learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 1 lakh rupees per annum. The tribunal has assessed the notional income of the deceased as 10,000 per month is on lawyer side. He was earning 1 lakh rupees from agriculture income and 15,000 per month as an electrician. The tribunal has assessed notional income of the deceased as 10,000 per month is on lawyer side. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, P. Pradeep, you have to see Mr. Interest ಎಷ್ಟಿದೆ ಅಂತ 9% ಇದೆ. Yes. P. Pradeep, learned counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 1,15,000 per month, he has not 1 lakh. Even though he has claimed that he was earning 1 lakh per annum as an agriculture income, 15,000 per month as an electrician, but he has not produced any document to establish the same. Therefore, the notional income assessed by the tribunal is just and reasonable. Lastly, he has contended that considering the age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal 9% is on higher side. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Who is that name of the deceased? What is the name? Shivlingaya died in road traffic accident occurred on 11/5/2019 due to rash and negligent driving of driver of car bearing registration number KA03 MU 1984. Even though
The claimant has claimed that he was earning 1 lakh rupees per annum from agriculture income and 15,000 per month from electrical work. He has not produced any document to establish the same. Under these circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2019, the notional income has to be considered as 14,000. The tribunal has rightly awarded 40% of the income of the deceased for future prospects and rightly deducted 1/4 of the income of the deceased for personal expenses, and the multiplier applicable to the age group 38 is 15. Accordingly, loss of dependency has been reassessed as follows. And in addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. Claimant number 2 and 3 are entitled 40,000 each for parental consortium. Claimant number 4 entitled 40,000 for filial consortium. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in court. Judgment and award passed to the tribunal is modified as follows.
For the appellant, my lord.
Permission to post before the division bench. Office note says the value of the appeal is more than 15 lakhs. Hence, post this matter before division bench having a roster.
Yes, my lord.
Name and the signature. Why? Elected. Sampath Kumar. ಎಲ್ಲಿದೆ ಅವ್ರ ಸಿಗ್ನೇಚರ್? ರವಿಶಂಕರ್, ಬೇಬಿ, ಸಂದೀಪ್, ಅಲ್ರಿ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲಲ್ರಿ? ಬೇಬಿ is there, ಸಂದೀಪ್ is there, ಎರಡು. ಮೋಹಿತ್, ಕೃಷ್ಣರಾವ್ ಅವರಿಗೆ ಎರಡು ವಕಾಲತ್ ಆಗ್ತದೆ. ಲೋಹಿತ್, what is his name? Yes. Submission of learned counsel for the appellant is accepted. Office objection is overruled. ಅದು ಒಂದೇನಾ? Issue notice. Yes. Acceptance of return of the check issued by the court instead of tribunal check bearing number so and so is in favor of the registry of. Yes. Yes, you want to withdraw and place it before the tribunal. The check submitted by the appellant is accepted. Yes. ಯಾಕೆ ಸುಮ್ಮನೆ ಅಲ್ಲ ಅಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಡು ಇಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ. ಎಸ್ ಕಂಪ್ನಿಯವ್ರ ಆರ್ಡರ್ ನೋಡಲ್ವಾ, ಚೆಕ್ ತಗೊಬೇಕಾದ್ರೆ. ಎಸ್ ಸಬ್ಮಿಷನ್ ಆಫ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಅಲ್ಲಲ್ಲ ಈ ತರ ಮಾಡಿ ಚೆಕ್ ಸಬ್ಮಿಟೆಡ್ ಬೈ ದ ಅಪಲೆಂಟ್ in favor of Registry High Court of Karnataka is accepted.
Proceed for appellant.
Yakre, then we will return it. You place it before the same list. Hereinafter we will not accept. Yes. When there is an order, you have to complain. Yes, same order.
Shantaraj K for appellant.
I appear for appellant. Claim petition has been dismissed against respondent number 2. Therefore, he has not made party to this appeal.
Counsel for the appellant has submitted that claim petition in respect of respondent number 2 is dismissed. Hence, he has not been made as a party in this appeal. Submission of learned counsel for the appellant is accepted. Office objection is overruled. That's one the objection, huh?
ಅದು ಒಂದೆಲ್ಲ ನೋಟ್ ಹೇಳಿದ್ದೆ, ನೋಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ಕೆ.
What ಹೇಳಿದ್ದೀರಾ?
ನೋಟ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ, ನೋಟಲ್ಲಿ ಅದು.
Submission of learned counsel for the appellant is accepted. Issue notice. Non-compliance of the office objection will not be called. IA 21 for recalling or not ordered. ಏನಿದೆ? Non-compliance with office objection. 2 weeks time is granted to comply the office objection. You are not complied it. What is this matter? Dismiss ಆಗಿರೋದೇ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ, ಆಮೇಲೆ ನೀವು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು. Yes. Finally, 2 weeks time is granted to comply the office objection. Yes. They have also filed an appeal. There is yaro only one respondent. Srimati HR Renuka. ಅವ್ರದ್ರಲ್ಲಿದೆ, ಅವ್ರ ತಪ್ಪಿದೆ. HR Renuka is directed to take notice to the 17.1. Renuka is directed to take notice for respondent number 1. The net counsel for the appellant is directed to serve one set of copies. Yes.
I appear for appellant, my lord. There is a delay of 69 days in filing appeal, my lord.
Government Insurance Department, why you have not filed wakalat, madam? Memo for appearance. Yes, government advocate is directed to. There is a delay of 69 days in filing an appeal. IA 1 of 2019 is filed for condonation of delay. Respondent number delay. Out the learned counsel for appellant for the reason stated in the accompanying affidavit. Delay of 69 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Ready?
The case bedded, my lord.
Yes. Yes, Mr. Girimale, what is
Death of a mother, aged about 70 years. Petition filed by the son and daughter, major son and daughter of the deceased. The tribunal has awarded 1,30,000. As per Virendra's case, out of the income, tribunal had to have taken the 50% of the income to assess the loss of dependency, my lord. That is not done in the case. 15,000 awarded towards the loss of estate, towards 15,000 funeral expenses, and 1 lakh love and affections. That's all the compensation award. Tribunal has come to the conclusion that she was earning 8,000 per month. Except saying the 8,000 per month, no amount is taken into consideration to award the loss of dependency.
They said it is not loss of dependency. It is for loss of estate since they are not depending upon the income.
Yes, as per recent judgment of the Birendra case, Mela, National Insurance Company versus Birendra, 50% of the income is to be taken to assess the loss of dependency, even if the appellants are the majors. KCJ 2020-759,
Any citation?
ACJ 2020-759, my lord. National Insurance Company versus Birendra and others.
What is that income?
Claimed income is 9,000 per month. Date of accident is on 2018. 2018, my lord. 22/4/2018.
What is that tribunal has taken?
8,000 at the conclusion, but 8,000 per month at the conclusion.
You have claimed 9,000.
Yes, my lord.
What is the age?
70 years at the time of the accident.
70.
70.
Yes, madam. Sri Girimalaya, Burnett Council appearing for claimant has contended that at the time of the accident, deceased was earning 9,000 per month. The tribunal has assessed the notional income of the deceased as 8,000 is on lower side. He further contended that even though the claimants are major, not depending upon the income of the deceased, contended that the claimants are entirely depending upon the income of the deceased. He further contended that even if they are not depending upon the apex court in case of National Insurance Company Limited versus Virendra and others, 2020 ACJ 759 has held that the claim of the claimant cannot be limited to conventional head, even though they are not fully depending upon the deceased. The tribunal is error in only granting loss of estate instead of loss of dependency. He further contended that in view of judgment of apex court in case of Magma, claimants are
daughter and son.
the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. The government advocate is directed to take notice of that. So and so, government pleader appearing for respondent has contended that the claimants are major son and married daughter.
Yes, my lord.
Married daughter, they are not depending upon the income of the deceased. Therefore, tribunal has rightly held that they are entitled only loss of estate. If she further contended that at the time of the accident, deceased was aged about 70 years. Considering her age, the notional income assessed by the tribunal is just and reasonable. Lastly, she has contended that the interest awarded by the tribunal 8% is on higher side. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. Liability and dispute va?
No dispute, madam. They have accepted the liability and satisfied the award.
It is not in dispute. Venkatamma alias Achamma died in road traffic accident occurred on 22/4/2018 due to rash and negligent driving of
Ambulance bearing registration KF42G 0943.
Venkamma alias Achamma died on 30/4/2008 due to road accident occurred on 22/4/2018 due to rash and negligent driving of driver of ambulance bearing registration number KA42G 0942. The claimant has claimed that deceased was earning 9,000 per month, even as per personal income as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2018 is 12,500. Under those circumstances, the notional income claimed by the deceased, the income of the under these circumstances, the monthly income of the deceased can be assessed as 9,000 per month. The apex court, in case of Virendra and other Supra, has held that whether the married and earning sons of the deceased being a legal representative can claim the compensation for death of their mother. The tribunal has, the apex court has held that tribunal was duty bound to consider their claim application filed by paragraph so judgment apex court in paragraph 10 and 15 extract. By reading the above said judgment, it is clear that it would be incumbent on the tribunal to consider the claim petition, notwithstanding concerned legal representative not fully depending upon the deceased. Considering the above said apex court judgment, the division bench of this court in MFA 7318 of 2015 disposed of on 23 October 2020 has held that 50% of the income of the deceased has to be considered for loss of estate. In view of the above, the 50% of the income of the deceased has to be considered for loss of estate. At the time of the accident, deceased was aged about
70. 70 years.
70. The multiplier applicable to that age group is
5.
5. Accordingly, loss of estate has been reassessed as follows. In addition, 15,000 for loss of funeral expenses. Loss of estate, madam, funeral expenses. In view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each for parental consortium. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Government advocate is permitted to file memo within 4 weeks from today.
Much obliged.
And I appear for the
Yes.
appellant, my lord.
Yes. Dispensation of production of certificate copies. Why, Mr. Why you have not produced the certificate copy?
Not the certified, no, certificate of depositing the amount.
Certificate by commissioner along with the copy of dispensation of the production of certificate of commission. Deposited the amount.
My lord, he is not the employer, my lord. Actually, he was a co-worker. Wrongly, my lord, the judgment foisted liability on him.
No, but it is a statutory provision. You cannot dispense.
Correct, but it says, my lord, that any appeal by the employer shall be accompanied by the certificate. Lord, he is not the employer, my lord. In fact, he has not been served with notice. He was a co-worker. Lord, second respondent is the contractor and employer.
That has to be decided by the only after admitting a case.
Now, my lord, what happens? Lord, he is actually 8 lakhs and odd is ordered. He cannot even afford to deposit, my lord. Otherwise, if appeal is not entertained, he has to suffer the decree.
No, but that is the law. What we have to do? There is a direction from this court also in that division when said it is mandatory. You have to deposit. Otherwise, it cannot be entertained. There is
My
a
submission is not, as he is not the employer.
no. That you have to be decide. You cannot decide yourself, is it not? Second thing,
Yes.
I have not applied for that commission. Have you appeared before the commission, Mr. Bhatt?
My lord, he was exalted.
You have no provision for recalling that order.
Lord, now it is already, my lord, 2019 order.
That is the remedy that you have not been given opportunity. Order is wrong. You have remedy to review. You can seek for that. Otherwise, to file an appeal, it is a mandatory provision.
First may dispose of the application. Lord, you will seek instruction with regard to the review, my lord.
No. That liberty I cannot give. If you have
Not liberty. I will get instruction. This application may kindly be.
No, you want time. I will grant. Get
Please.
instruction.
Your execution haki warrant.
You see, you think of what is that best method you can do it.
Yes. Yes.
The request of permission for the release this matter of 2 weeks.
One date code is on.
When do you want?
Lord, on 23rd, my lord. Yes.
Yes. Union of India Postal Crash Report. Then the third, why that Union of India? Central government vehicle. Yes. there is a delay of 592 days in filing an appeal. IA-1 of 2022 is filed for condonation of delay. The respondent is served unrepresented for the reason stated in the accompanying affidavit. Delay of 592 days in filing an appeal is condoned. IA-1 of 2022 is allowed. Heard. Issue rule. Heard admit. Yes. Shastri. Filing furnishing cover issue notice. Also for second time. Postal Sara asset known number of 6 class. There is Shastri. Is it liability is dispute, Mr. He is also not there. Yes, then appear for responding appellant. We'll discuss this matter next week. ಅಲ್ಲ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೋಟಿಸ್ ನೋಡ್ಬೇಕು ಲಯಬಿಲಿಟಿ ಏನಾರ ಇದ್ರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗ್ದೇನೆ ಡಿಲೇ ಕಂಡನ್ ಮಾಡಕ್ತಾರ ಅದಕ್ಕೋಸ್ಕರ ಆಸ್ಕಿಂಗ್ ವೆದರ್ he said IA-1 of 21 will not pass. IA-21 of Learned Counsel for the appellant submits that IA-1 of 21 may be dismissed as not trust. Yes. ಯಾರು ಫೈಲ್ ಮಾಡಿದಾರಂತೆ ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ. N. Krishnasamy is directed to take notice for respondent number 1. Week's time is granted to file pay the process to issue notice to respondent number 2. Learned Counsel for the appellant submits that this appeal may be called along with that. Yes.
I appear for appellant, my lord. I may be permitted to take notice to R1, my lord.
Who is R1?
R1 is the owner of the vehicle. There is a pay and recover order is there. I have to take some.
Week's time is granted to pay the process to issue notice to respondent number 2 na?
1. My lord.
Yes. Yes, respondent 2 notice to be ordered, notice order ಮಾಡಿಲ್ವಾ? Issue notice to ಅಲ್ಲ ಯಾರಿಗೂ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Seshkir Rao has filed the wakalat in this case.
ಆಯ್ತು, but we can say, but somebody has to say notice has not been ordered.
Yes.
Issue notice. YK Seshkiri Rao has filed an wakalat for respondent number 2. The same is accepted. Issue emergent notice to respondent number 1.
Much obliged.
Yes. Memo filed for dispensation of notice to R2 is dispensed. There is a delay of 176 days in filing an appeal. IA-1 of 20 is filed for condonation of delay. For the reason stated in that affidavit, delay is condoned, subject to condition, not entitled for the interest. ಯಾವ್ದು ಅದಕ್ಕೆ? What is that income? 3,000 ತಗೊಂಡಿದ್ರಾ? 8,000. ನೀವು ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? 10,000. ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟಿದೆ? ಅದು ಕರೆಕ್ಟ್ ಇದೆ. ಮತ್ತೆ ಇದು 10% ಮಲ್ಟಿಪ್ಲೈಯರ್ ಮತ್ತೆ ಇದರಲ್ಲಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 15,000 ಎಕ್ಸ್ಟ್ರಾ ಮಾಡಿ ಅಂದ್ರೆ 40. ಇನ್ನೇ ಅದಕ್ಕೆ ಮತ್ತೊಂದು ಲಾಸ್ ಆಫ್ ಕಮ್ಯುನಿಟೀಸ್ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 15,000. 35. ಅದು as per the 3 months ಬರುತ್ತೆ. 3 months ಅಷ್ಟೇ ಅಲ್ಲ sorry. So learned counsel appearing for claimant has contended that at the time of the extent, claimant was earning 10,000 per month. The tribunal has considered notional income of the claimant as 3,000 per month is on lower side. He further contended that due to that extent, the claimant has suffered grievous injury. How many days inpatient, Mr. Raj? Inpatient. He was inpatient for a period of 27 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shivane Gowda, learned counsel appearing for insurance company has contended that even though the claimant has claimed that she was earning 10,000 per month, she has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 3,000 per month. He further contended that considering that injury suffered by the claimant, considering that evidence of doctor, the tribunal has awarded just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 28/3/2013 due to rash and negligent driving of driver of Canter bearing registration number KA 367447. Due to that extent, the claimant has suffered the following injury. Considering that evidence of doctor, considering that wound certificate, the tribunal has rightly assessed the whole body disabilities as 15%. Even though the claimant has claimed that she was earning 10,000 per month, she has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2015, the notional income has to be considered as 9,000. The multiplier applicable to the age group. Yeah, ಎಷ್ಟು year? ಅಲ್ಲ ಎಷ್ಟು ವರ್ಷ ಅಂತೆ 30 ವರ್ಷ. For 30, how much is 17? The multiplier applicable to the age group 30 is 17. Accordingly, loss of future earning has been reassessed as follows. $8,000. Oh, 8,000. Accident was year 2013, Allah. 13, 8,000. When that income 10,000, the tribunal assessed 3,000. 8,000 in lieu of that charge 8,000. Yes. Due to that extent, the claimant has suffered previous injury. She was inpatient for a period of 27 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 40,000. Loss of immunities from 20,000 to 35,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award. Leave of order dated. So also, the claimant is not entitled for the interest for a period of 176 days. Yes, Vijay Kumar.
ಸರ್ ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
He is in other court. Secure records ಬಂದಿದ್ಯಾ? On what ground they have challenged? Yes. Records ಬಂದಿಲ್ಲ. Office is directed to secure records post immediately after receipt of the records. The records ಒಂದೇ ಸಾರಿ ಮಾಡ್ಬಿಡೋಣ. Instead of considering, in the meantime, the respondent appellant is directed to pay the process to issue notice to respondent number 2. The respondent number 2 ಅಲ್ಲ. 3 ನಾ? ಹಿಂಗ್ ಮಾಡಿ. Yes, Madhay Swami is undertaken to appear for respondent number 3. Office is directed to secure original records from the tribunal post immediately after receipt of the records. ಇಲ್ಲ ಬಂದಿಲ್ರಿ. Records ಬಂದಿಲ್ಲ ನೋಡಿ. Post immediately after ಬಂದ್ರ ಅದ್ರ ಜೊತೆಗೆ post. Yes. Yes. IA 1 of 21 is dismissed as not trust. Issue notice. Yes, same. Same. Yes, same.
I appear for appellate. 32 ನಲ್ಲಿ I sought for stay, my lord. ಇದರಲ್ಲಿ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಈಕ್ವಲಿ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಪೇರೆಂಟ್ಸ್ ಗೂ 67% ಕೊಟ್ಟಿದ್ದಾರೆ, ವೈಫ್ ಗೆ 33% ಕೊಟ್ಟಿದ್ದಾರೆ. Lordship and see ink page 22 para 31 of the judgment, my lord.
You are wife.
Wife, my lord, I am the wife. Our aged parents ಅವ್ರಿಗೂ 33%, ಟೋಟಲ್ 67% ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಬ್ಬರಿಗೆ 33, ಎಲ್ಲರಿಗೂ 33 ಮಾಡಿದಾರಾ?
ಹೌದು.
Notice stay of judgment and award dated 30th November 2021 passed by MACT Tumkur in MEC 138 of 2020 till next date of hearing.
ಅಲ್ಲ, so far as apportionment ಅಂತ ಮಾಡ್ಬಿಡಿ, ಇಲ್ಲಾಂದ್ರೆ ನಾವು ತಗೊಳಕ್ ಆಗಲ್ಲ ಅದು.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಯಾರು ಬೇಡ ಬರ್ಲಿ.
ಅಲ್ಲ, ಬೇಕಾದ್ರೆ 10% they are entitled for 10% each, my lord. That can be, they can withdraw, my lord.
That will decide. You serve the copy, then we'll decide that. Only apportionment ಅಷ್ಟೇ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು.
Apportionment ಅದು ಇದು. This case ಇದರಲ್ಲಿ ಅದೇ ನೋಟ್ ಇದು ಮಾಡಿ ಅದರಲ್ಲಿ ಇದು ಸತ್ಯಿತ ಇದು.
During the pendency of the claim petition, appellant number 1 is that 1A LR. Who is petitioner number 2?
ಅವರು ಇದು ಡಾಕ್ಟರ್, ಅವಳು ಮರ್ಡರ್ ಆಗೇನೋ ಸತ್ತೋದ್ಲಂತೆ, ಅದಕ್ಕೆ ಹಂಗಾಗಿ.
In which MEC this is?
This is MEC 1023 of 17. 1023 of 17.
Yes. Daughter, she is unmarried.
Unmarried. Minor idlu ಅವಳು.
The submission of learned counsel for the appellant is accepted. Office objection is overruled. IA 2 of 2022 is dismissed as not trust. Issue notice. Yes. So that what is the finding of the tribunal? Yes. Yes. Issue notice. Stay of judgment and award dated 23rd December 2017 past 5. MECT Pandapura in MEC 780 of 2016. Subject to condition. The appellant has to deposit the entire compensation amount with interest before this court within 4 weeks. Before this court.
35, my lord. I am for the appellant, my lord. I am not pressing IA1, my lord. Serial number 35, my lord.
ಆಯ್ತಲ್ರಿ ನೋಟಿಸ್ ಆಯ್ತು ಬಿಡ್ರಿ.
Please.
Yes. What is Raja? Shri Lingaraju is directed to take notice for respondent number 2. Each time is granted at the MFA 40.1. Shri Lingaraju is directed to take notice for respondent number 2. Each time is granted to pay the process to issue notice to R1 without postal Sarah. R1 and 2 second time. R1 without postal Sarah. Each time is granted to pay the process. R1 main postal Sarah. Yes. Week's time is granted to pay the process issue notice to R1. Office is directed to secure original records.
I appear for appellant in first matter.
Who is that R2?
R2 is the ಇದು ಏನು ಕೃಷ್ಣಸ್ವಾಮಿ ಜೂನಿಯರ್ ಮೆಸೇಜ್ ಕಳ್ಸಿದ್ರು ಐ ವಿಲ್ ಟೇಕ್ ಟೈಮ್ ಅಂತ ನಾನು ಅದಕ್ಕೆ ಫೈಲ್ ನೋಡಕ್ ಹೋಗ್ಲಿ.
So is owner ಇರ್ಬೇಕಂತ ಕಾಣ. In their case they have to take a process.
ಅದೇ ಅದಕ್ಕೆ
In MFA 42.1 ಅಲ್ಲಿ week's time is granted to pay the process to issue notice to R2. Yes. Yes, Nagaraj. ಅದರಲ್ಲಿ 42 ಅಲ್ಲಿ office is directed to secure records. Nagaraj.
Melod, I appear for the appellant, KSRTC.
Have you deposited that amount?
But we have deposited, Melod, I don't have the particulars. But I'm ready to go on with the matter itself. Matter could be disposed of, Melod.
Oh, other side is not there. R1 Purushottam third, Nagaraj. ಏನ್ರಿ ಅದು?
ಅವ್ರದ್ದು ಅಪೀಲ್ ಇದೆ. ನೆಗ್ಲಿಜೆನ್ಸಿ ನಮ್ದೇನು ಅಷ್ಟೊಂದು ಸೀರಿಯಸ್ ಇಲ್ಲ.
problem is that, yes, Pawan Kumar YN is directed to take notice for respondent number 1. Release this matter next week. ಏನಾಯ್ತು ಪಾಟೀಲ್? ಯಾಕೆ R1 ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯಲ್ಲ, ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಆಯ್ತು, ನಿಮ್ದ್ರಲ್ಲಿ ಆಗ್ಬೇಕಲ್ಲ. ಎಸ್, ಅವ್ರಿಗೆ ಆಗ್ತದೆ.
ನೆಗ್ಲಿಜೆನ್ಸ್ ಏನು ಅಷ್ಟು ನಮ್ಗೆ ಇದಿಲ್ಲ ಸ್ವಾಮಿ, ಕ್ವಾಂಟಮ್ ಮಾತ್ರನೇ.
Nobody is representing other side, Mr. Nagaraj.
Please, sorry.
ಯಾರ್ದು ಅವ್ರದ್ದು ಇದೆಯಾ? Single judge decision maker. Yes, Bernard counsel for the appellant has submitted that this appeal may be filed along with so and so. Yes.
In this appeal, I pay for the appellant, private is owner, but liability has been fastened on the.
ಅಲ್ಲ 46 and 10 ಕಾಂಟ್ರಾ ಯಾರು? ರಾಜಶೇಖರ್ ಯಾರು? Gopal Krishna may be taken as. Yes. Ready, Mr. Nagaraj?
Yes, ma'am. But in this appeal, my lord, I have filed this appeal on behalf of owner of the private bus, challenging judgment and award on the ground that my lord, insurance company has been exonerated for the reason that my lord, I have operated the bus beyond the permits. Lord, my submission is I have operated the bus not for carrying the passengers, but for
insurance company. They are the contesting. Where is K.N. Srinivas? He has to answer. Yaar K.N. Srinivas? Bartara. Pass over, Mr. Nagaraj.
And it will take some time, my lord, after our evidence ಬೇಕಾಗ್ತದೆ.
Yes. None appear for our Karkabani. He is ready. If he is there, we could have completed. ಸರಿ, ಅವ್ರು ಇಲ್ಲಲ್ಲಪ್ಪ ಈಗ, ಯಾಕೆಂದ್ರೆ yes, none appear for respondent number 8 as a last chance. Release this matter next Friday. Yes. Where is Ravi? Owner is liable. Why? You are appearing for the owner. Why? What is that instruction you want to get? No, what statement we can file here? This is an appeal. No, that. No, if you are in a this thing, you have to get an why that owner has been insurance company exonerated. Huh? Permit is not there in pay and recovery. Adu madilva? Yes, who is appearing for insurance company? Ravi Sampath. You can do it pay and recovery if the permit is not there. That's all. Yes, when do you want next week? Yes. Let us see if there is permit is there. Let him produce along with the records. Yes, yes, that will see first whether you are liable or not. Yes, at the request of counsel for R1, release this matter next week.
Number 49, KJ for Appellate. R1 release.
ಏನಿದು ಸಿಗ್ನೇಚರ್ ಆಫ್ ದ ಅಡ್ವೊಕೇಟ್ ಇನ್ ಕಾಂಪ್ರಮೈಸ್ ಅಗ್ರಿಮೆಂಟ್ ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅದು ಇದ್ರದೇ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಯಾಕೆ ವಾಟ್ ವಾಸ್ ಹಿ ವಾಟ್ ಈಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಕ್ಲೈಂಟ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಕ್ಲೈಮೇಟ್ ಮ್ಯಾನ್ಸನ್ then why tribunal has not considered para 17 just read ಅದನ್ನೇ ಸರ್ಜರಿ ಆಗಿಲ್ಲ ಫ್ರಾಕ್ಚರ್ ರಿಯುನೈಟೆಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ 7.5% ಹೋಲ್ ಬಾಡಿ ಎಷ್ಟು ಬರ್ತದೆ ಎಲ್ಲೈತೆ ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಕೊಡಿ ಡಾಕ್ಟರ್ ಎಲ್ಲಿದೆ 30% ಅಂತ yes 30% limitation of fiscal extension right elbow 30% limitation of flexina extension arc in the right elbow a disability ಅಲ್ಲ ಅದು ಮೂವ್ಮೆಂಟ್ಸ್ 30% ಕಡಿಮೆ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಡಿಸಬಿಲಿಟಿ ಇಸ್ ಎಟ್ 7.5%. 7.5% ಗೆ ಒನ್ ಥರ್ಡ್ ಆದ್ರೆ ಎಷ್ಟು ಬರ್ತದೆ ಪರ್ಮನೆಂಟ್ ಫಿಸಿಕಲ್ ಇಂಪೇರ್ಮೆಂಟ್ to that limb. If you take whole body, then it will come 2% ಬರೋದು 3% ಬರೋಲ್ಲ half ತಗೊಳ್ಳಿ 3% ಆದ್ರೆ ಎಷ್ಟಾಯ್ತು ವಾಟ್ ಇಸ್ ದಟ್ ಮಂತ್ಲಿ ಇನ್ಕಮ್ ಅಲ್ಲ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ 17 ಎಷ್ಟಿದೆ 11,016 5,500 into 3 what is the multiplier what is his age mister 58,000 50 ಕೊಟ್ಟಿದಾರಲ್ಲ ಗ್ಲೋಬಲ್ ಲೈಡರ್ ಪೀರಿಯಡ್ ಏನು ಬರೋದಿಲ್ಲ. ಎಲ್ಲಿದೆ ಹಾಸ್ಪಿಟಲ್? ಎಷ್ಟು ದಿನ ಐತ್ರಿ? ವೇರ್ ಇಸ್ ದಟ್? Yes, it is 3% will take. Sri Tejas N. Bernard Council appearing for Climate has contended that due to that extent, the climate has suffered grievous injury. He has examined Dr. Raghunath R as PW2. In his evidence, he has deposed that the climate has suffered 30% limitation of flexina extension arc in the right elbow and 7.5% permanent physical impairment. The tribunal has failed to assess whole body disabilities and has not granted any compensation for future loss of income. Secondly, he has contended that due to that extent, the claimant has suffered previous injury, was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. The tribunal has granted only a global compensation of 50,000 rupees. Hence, he sought for enhancement of compensation. Per contra, Sri Reddy, Bernard Council appearing for the insurance company has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 4 days. That he has not undergone any surgery. The fractures are reunited. The fractures are united, fully united, and doctor has not assessed any whole body disabilities. Therefore, the tribunal is justified considering the global compensation of rupees 50,000. Lastly, he has contended that the interest 7% awarded by the tribunal is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 18/9/2016 due to rash and negligent driving of Tata Ace bearing number KA 42A3812. Due to that extent, the claimant has suffered the following injury. He has examined Dr. Raghunath R as PW2. In his evidence, he has deposed that the claimant has suffered 30% limitation of flexina extension arc in the right elbow and 7.5% permanent physical impairment. Considering that evidence of Dr. Raghunath and considering that wound certificate exhibit P5, I am of the opinion that the whole body disabilities can be assessed 3%. Just claim madidre income. Even though the claimant has claimed that he was earning 500 per day, he has not produced any document to establish the same. In the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 28 years. The multiplier applicable to the age group is 17. Accordingly, Loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the opposite injury. He was inpatient for a period of 20 days. Yeah, 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering the same, I have the opinion that the claimant is entitled 20,000 for pain and suffering, 20,000 rupees for 25,000 rupees for pain and suffering, 25,000 rupees for loss of immunities, and he is entitled 1,000 rupees for only 1 month for loss of income during the later period, and 5,000 rupees for till 1 month, 5,000 rupees for food nourishment. August 20, 8,000 50.
1,22,640.
Instead of global compensation 50,000 has to be enhanced to total compensation of 1 lakh. The interest enhanced compensation amount carries 6% interest. Ready next week at the request of counsel for the parties. We list this matter next week. Today, ನೀವು ರೆಡಿ ಇದ್ರೆ ಇವತ್ತೇ ಪಾಸ್ ಅವ್ರ ಏನಕ್ಕಪ್ಪ ನಿಮಗೆ ಟೈಮ್? ಎಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ.
Reliance. I'll take notice.
Vijay Kumar is directed to take notice for respondent number 2. ಏನೋ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಸರ್ವ್ ಆದ್ರೆ ಒಬ್ರು ವಕಾಲತ್ ಹಾಕಲ್ಲ. ವೈ ಮಿಸ್ಟರ್ ರಾಮಕೃಷ್ಣ? Even that insurance company is served, they will not entrust the matter to any counsel.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ? You ask me kindly see the address given in the cost title. Address given in the cost title. ಅದು ಎಲ್ಲೆಲ್ಲೋ ಇದಕ್ಕೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಗಳಿಗೆಲ್ಲ ಮಾಡಿರ್ತಾರೆ.
ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ ಕನ್ಸರ್ನ್ ಇದಕ್ಕೆ
ಅದನ್ನ ಮಾಡ್ಬೇಕು, ಅದು ಮಾಡೋದಿಲ್ಲ, ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ.
D. Vijay Kumar is respondent number 2, served unrepresented. D. Vijay Kumar is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve 1 set of copies. Pastor, dismiss ಆಗಿದೆಯಾ? Then we will admit it. ಅಲ್ಲ, ಈ appeal filed by whom? ಅಲ್ಲ, ಯಾರು ಓನರ್ ಫೈಲ್ ಮಾಡಿದ್ರು? ಕ್ಲೈಮೆಂಟ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. Why it is dismissed? 163 proceedings. ಅಲ್ಲ, he is a claimant. 163 proceedings ಅಲ್ಲಿ how accident has occurred? Father, mother, date of accident, so prepared on a petition under so and so. The rider of the motorcycle driven the same on the public road. Proceeding on the said bike, the rider of the Anand has lost the control over the said bike and therefore he has felt first time head injury. Other injuries, please. Because of the head injury. Yes. Oh, he's a pillion rider. Is he pillion? Rider fast ಆಗಿ ಹೊಡೆದು ಬೀಳ್ಸಿದ್ದ ಅಂತ ಇವನು ಹೇಳ್ತಾನೆ. Yes. Day after tomorrow. Yes. Yes. Release this matter on Wednesday. Pass on. Pass on. Why, mister? ಅಲ್ಲ ಈ ಕ್ಷಣ ಕೊಡೋದಿರ್ಲಿ. Why you have not given that earlier? That is the see directed to take notice ಮಾಡಿಸ್ಕೊಂತೀರಾ, ಪ್ರೋಸೆಸ್ ಕಟ್ಟೋದನ್ನ ಉಳಿಸ್ತೀರಾ, ಕಾಪಿನೂ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ then will not direct that will ask you to pay that process. ಇಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಕಂಪನಿಗೆ ಹೋಗ್ತವೆ, ಅವು ಹೋಗ್ಬಿಟ್ಟು ಅದು ಮಾತ್ರ ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇರೋದು. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಸೀದಾ ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಹೋಗಿ ಅವ್ರಿಗೊಂದು ಎಂಟ್ರಿ ಇರ್ಬೇಕು. ಒಂದ್ಸರಿ ಹೋಗಿ ಅವ್ರ ಅಡ್ರೆಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದ್ರು ಕೂಡ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್. ಯಾಕೆ ಅಂತಂದ್ರೆ ಮತ್ತೆ ಎರಡೆರಡು ಸರಿ ಕ್ಲೈಮೇಟ್ಸ್ ಹತ್ರ ಕಟ್ಸಕ್ ಆಗೋದಿಲ್ಲ. ಆಮೇಲೆ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಟ್ ನೋಟಿಸ್ ಮಾಡ್ತಾರೆ. ಎಸ್ ಯು ಸರ್ವ್ ದ ಕಾಪಿ ನೌ. ಎಸ್ ಎಸ್ learned counsel for the appellant submitted that this appeal may be called along with that. ಇನ್ನೊಂದು ಕ್ಲೈಮೇಟ್ಸ್ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ರೆ ಏನು ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ then you give that copy. Learned counsel for the appellant has submitted that this appeal may be called along with that so and so next week. ಎರಡು ಹೊಟ್ಟೆ ಮುಚ್ಕೊಡ, ನೀವು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. In addition, sorry. See, Sidramaya learned counsel appearing for the claimant has contended that due to that extent the claimant has suffered grievous injury. How many days hospitalized? He was inpatient for 1 day, 2 days in the hospital, and he has spent 2 lakhs rupees towards medicines and other incidental charges. The global compensation awarded by the tribunal 75,000 is on lower side. Total compensation awarded by the tribunal 75,000 is on lower side. Hence, he sought for enhancement of compensation. For contra, the Ramakrishna learned counsel appearing for insurance company has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for the period of 2 days. Doctor ne examine madilla. He has not examined the doctor. Therefore, the global compensation, the total compensation awarded by the tribunal, 75,000 rupees, 6% interest is just and reasonable. 30% more inclusive. Lastly, then you will say that 30,000 by consent. Consent ಅಂತ ಅವ್ರು ಬೇಡ, ಅದಕ್ಕೋಸ್ಕರ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಒಪ್ಕೊಂಡಂಗೆ ಆಗುತ್ತೆ ಅಂತ. ಇಟ್ ಇಸ್ ನಾಟ್ ದ ಕೋರ್ಟ್ ಆರ್ಡರ್. ಅದಕ್ಕೋಸ್ಕರ ಇಬ್ರು ಒಪ್ಕೊಂಡ್ರೆ ಮಾತ್ರ ಕನ್ಸೆಂಟ್ ಆಗುತ್ತೆ, ಅದರ್ವೈಸ್ yes. I heard the learned counsel for the parties. Perus judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 30/1/2014 due to rash and negligent driving of rider of bike bearing registration number KA06EH1135. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 2 days. Considering that injury suffered by the claimant and considering that wound certificate exhibit P6 and discharge summary exhibit P10, in addition to that compensation awarded by the tribunal, 30,000 rupees has been awarded without any interest. Accordingly, the appeal is disposed of. In view of ಇಲ್ಲೇದೇನು ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ there is no interest has been awarded. Yes, yes. Yes, Suresh.
My lord, I am for the appellant in the connected matter. My lord, we have deposited 3,85,000 rupees before this honorable court. The office has raised the objection that we have not deposited 25,000 rupees. The same may be treated as the statutory deposit, my lord, and records may be called for. It can be disposed of anytime.
Yes. Who is that respondent in your case?
Suresh M. Lathur.
ಈಗ ಅವರೇನಾ?
ಹೌದೌದು.
ಇದ್ಯಾರು ಪ್ರೊಪರೈಟರ್ ಮೆಗಾ ಟ್ರಾವೆಲ್ಸ್?
That I'll file an application for this thing, my lord. Dispensation. He remained ex parte before the tribunal.
Suresh Lathur is directed to take notice for his undertake to appear for respondent number 1. Shri D. Vijay Kumar, Bernard Council appearing for the appellant in MFA 3806 of 2022. Through VC submitted that notice to respondent number 2 may be dispensed. To that effect, he will file a memo in that office. Submission of learned counsel for the appellant is taken on record. Notice to R2 is dispensed. Since he further submitted that he has deposited 50% of the award amount before the tribunal.
ಇಲ್ಲ ಅದು almost full amount ಮಾಡಿದೆ.
Deposit ಮಾಡಿದಿರಾ?
3,85,788.
3,85,788. Submission is taken on record. The office objection in respect of deposit of statutory amount is overruled. Yes.
My lord, I sought for stay, my lord. This amount may be fixed, kept in a deposit till disposal of the appeal.
Yeah. Judgment and award dated 2/3/4/2 of 20 judgment 11th January 2022 passed by MACT Bangalore in MEC 2/3/4/2 of 2020. Yes, still next date of hearing.
My lord, records may be called for, my lord.
Directed to secure original records.
After receipt of records, my lord, matter may be posted.
Yes, yes. Yes, Mr. Yes, what is this? Pass on. We'll hear that. Here also. So if only for this thing, quantum, then it is not necessary. We'll pass out. Let us see 230. 230.
May make one submission, my lord. My lord, in the previous case, my lord, stay may be until further order ಅಂತ ಮಾಡೋದಾಗುತ್ತೆ. ಯಾಕಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ನಮಗೆ ಮರ್ತೋಗ್ಬಿಟ್ರೆ ಸ್ಟೇ ವೇಕೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ. Until further order, please. Much obliged.
ಎಷ್ಟಿದೆ? ಎಕ್ಸ್ಟ್ರಾ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 9%. Interest has to reduce. Yes. What is the ground they have raised in that appeal? Assessing the compensation in the system, adopted erroneous method, the member of the error in the document instead of page of the system. Signal error in applying that rendering the system that as in Suresh Sagra, which did not lay down the law with respect to the quantum of money, has to be granted for death of 6 years old child. Then member of the criminal error in awarding the 20% under the payment. Criminal has considered that Kishan Gopal. Consider rendered by the Honorable Supreme Court in case of Kishan Gopal, Lala and the others reported also, which did not lay down law with regarding to the quantum of compensation that has to be granted for death of 6 years old child. What is the age of the deceased? 6 years. Kishan Gopal al ಎಷ್ಟು ವರ್ಷ ಇದೆ? Yes, that will not make any difference. ಅದು ನಮ್ಮ ಇದಕ್ಕೆ ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ we have adopted the rules applicable to that CPC has been adopted under Karnataka motor vehicles rules. Therefore, division bench held. Yes, where is Sitaram? Pass off. But that you are appearing for M.E. Nagesh for owner. On what ground, Mr.? Huh? What is the finding of the tribunal? ಅಲ್ಲ ಪರ್ಮಿಟ್ ಇಲ್ಲದೆ ಇದ್ದಿದ್ರು ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಯಾಕ್ರಿ ಲಯಬಿಲಿಟಿ ನಿಮ್ಮ ಮೇಲೆ ಹಾಕ್ತಿದ್ದಾರೆ? No, I am asking why the tribunal has motor vehicles act must deviation of the route permit at most paying the vehicle deviation to permit amounts to violate the condition of policy. Exonerated the liability of the criminal intervention. ಅದೆಲ್ಲ ಇದೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮನೆ ಅಂತ ಕೊಡಲ್ಲ ಪರ್ಮಿಟ್. No, they said ಅದು ಮನೆ ಕೊಟ್ಟಿಲ್ರಿ ಒಂದು ಟ್ಯಾಗ್ ಹಾಕಿ ಪರ್ಮಿಟ್ ಅಂತ ಒಂದು ಟ್ಯಾಗ್ ಹಾಕಲಿ ಅಂತ ಕೃಷ್ಣ ಭಟ್ ಮತ್ತೆ ಸುನಿಲ್ ದೇಸಾಯಿ. Yes, division bench has held paint recovery. Yes, yes. No, you just see two things. If you have a permit, then only you have a case. No, if you are violated the permit, then also pay and recover. That is what that division bench, even the Supreme Court in Rani case. Yes, will be. When do you want? Yes. When do you want? Next Friday. Next Friday.
I'm the advocate for the appellant.
Yes, what is your case, madam?
It is only on quantum.
Yes.
Your Lordship, in this case, the deceased was aged 26 years at the time of accident. Accident is of the year 2016. Your Lordship, internal page 11, paragraph 15 may be just, I may just be permitted to read internal page 11, paragraph 15. One Shri R. Mohan is examined as PW3. He has deposed that he came to know that deceased Lokesh had expired pursuant to a road accident on 23/9/16 at 8 p.m. at the chicken shop of PW2. The deceased Lokesh was doing welding work in MS Rajmohan Engineering Works, which is owned by him since 2 years and was being paid salary of rupees 700 per day. He has produced the notarized copies of his business license and Aadhaar card as exhibit P17 and 18. During his cross-examination, he admits that he does not have any documents to show that the deceased was working in his welding shop since 2 years, or that he was paying rupees 700 to the deceased as his daily wages. Your Lordship, in this case, P16 is the letter given by PW3 itself, R. Mohan, saying that he was paying 700 rupees per day. He is cross-examined as PW3. And he also admits that he was paying 700 and he was doing welding work. 17 and 18 are the licenses produced by Mohan, saying that he has a welding business, that is exhibit P17 and 18. Hence, my contention is rupees 700 per day may be taken as the income.
Oh, who is the PW2?
PW2 is the who has witnessed the accident. PW3 is R. Mohan, who was his employer.
R. Mohan.
Yes, R. Mohan. Your Lordship, I may be permitted to read PW3 evidence. Evidence of PW3, the last para, the next page. Sadari Mrita Lokesh Anu Nanna Malikatva Raja Mohan Engineering Works Nalli Kalede 2 ವರ್ಷದಿಂದ ವೈರಿಂಗ್ ಕೆಲಸವನ್ನು ಮಾಡಿಕೊಂಡು ಆತನಿಗೆ ದಿನ ಒಂದಕ್ಕೆ ರೂಪೀಸ್ 700 ಸಂಬಳವಾಗಿ ನೀಡುತ್ತಿದ್ದೆನು. Plus, he also tells in his cross-examination. I also do not have any documents to show that I was paying 700, 800 to the deceased as his daily wages. It is false to suggest that the deceased was never employed by me in my welding shop and earning 700 per day. Even exhibit P16, P17 and 18 may be looked into.
What is that? P16, 17.
P16.
Yes.
P16, he tells in the 4th line, ದಿನಗಳು ನೌಕರನಾಗಿದ್ದು ಆ ದಿನಗಳಿಂದ ರೂಪೀಸ್ 700 ಮಾತ್ರಗಳನ್ನು ಪಡೆದಿದ್ದಾರೆ. Means he gives 700 rupees. Is exhibit P16 also he is given the certificate of Rajmohan Industries, R. Mohan's industry.
So No document you have produced before accident.
No
It is
documents were
after
produced.
the accident.
After the accident, his employer has produced this. Again, P17 is R. Mohan's. It shows that his industry, his registration number of his industry. P17 also being looked into.
He has not stated that whether he was paying that by cash or by check.
That he has not stated. He says that he was paying 700 per day.
You have also not produced even any bank statement that amount has been remitted.
No, I have not produced any bank statement. Again, I have produced exhibit P13 from the Tahsildar saying that I was working as doing welding work and getting 700 per day. Exhibit P13.
Who is that has given?
Tahsildar.
How Tahsildar is concerned about that?
Just has given a certificate that he was doing welding business.
And also said 700 has paid. Our Arjil ಹೇಳಿರೋದು ಅಷ್ಟೇ. He is not that witness that. How can he say, madam?
I leave it to your lordship.
It's a case of death.
Yes, it's a case of death.
What is that amount tribunal has considered?
Tribunal has considered income at 6,000 plus 40% future prospects.
ಕೊಟ್ಟಿದ್ದಾರೆ future prospects.
ಹೌದು 40% future prospects ಕೊಟ್ಟಿದ್ದಾರೆ. Page 17, internal page 17, para 24.
Yes.
6,000 is taken plus 40% is taken. Multiplier is 17 is correct.
He's a bachelor.
Yes, he's a bachelor. Half is deducted. 50% is deducted.
Then loss of estate has been given. Medical expenses has given. Consortium, who are the claimants?
Parents.
They required another 80,000 under that.
And medical expenses may be retained.
Yes, yes.
And 9% interest is given.
Yes, where is Ravi Shankar? No, if you have no objection for considering the notional income as per the chart, I can dispose of 9,500. Yes, correct. Because even if he is there also, that will cannot be disposed.
It may be disposed of.
Also, Bernard Council appearing for claimant has contended that at the time of the accident, deceased was aged about 26 years. He was earning 700 per month as a welder working in Rajmohan Industries. To that effect, he has produced certificate issued by the employer as exhibit P16. and employer has been examined as PW3. He has categorically stated that the claimant has been paid, the deceased was been paid as 700 per day. The tribunal has failed to consider this aspect of the matter has taken that monthly income of deceased was 6,000 per month is on lawyer side. She further contended that in view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. Hence, sought for enhancement of compensation. For contra, Sri Ravi Shankar, learned counsel appearing for insurance company, has contended that even though the claimant has claimed that deceased was earning 700 per day and they have produced exhibit P16, but they have not produced any document, exhibit P16, which is issued after the death of the deceased. No document has been produced related to income of the deceased before his death, and no bank statement has been produced to show that he was receiving 700 per day. Therefore, the tribunal has rightly assessed the notional income of the deceased as 6,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. The claimant as Lokesh died in road traffic accident occurred on 23/9/2016 due to rash and negligent driving of driver of lorry bearing registration number KA19A3941. Even though the claimant has claimed that deceased was earning 700 per day and they have produced the certificate issued by the employer as exhibit P16 and they have examined the employer as PW3. They have not produced any document. They have not produced the bank statement to show that the deceased was receiving 700 per day. Considering that same, I'm of the opinion that under those circumstances, the income of the deceased has to be assessed notionally as per the guidelines issued by Karnataka Legal Service Authority for the accident occurred in 2016. The notional income has to be assessed as 9,500. The tribunal has rightly considered 40% of the income of the deceased for future prospects and rightly deducted 50% of the income of the deceased for personal expenses since deceased is a bachelor. At the time of the accident, he was aged about 26 years. The multiplier applicable to the TH group is 17. Accordingly, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. The medical expenses awarded by the tribunal is retained. The enhanced compensation amount varies 6% interest. Accordingly, the appeal is disposed of.
Lordship's kind leave, with your Lordship's kind leave, my lord, my name may be deleted, my lord. R. Srinivas Gowda appearing for respondent number 1.
Where is Srinivas Gowda? Then what is your case? Yeah. ನೀವು ಇನ್ಕಮ್ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? Yes. Yes. What is doctor evidence? What are that injury, Mr.? ಡಾಕ್ಟರ್ ನೇಮ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಕ್ಲಾಸ್ ಮಾಡಿ. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ? ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು 12% ಮಾಡಿದ್ದಾರೆ. ಇನ್ಕಮ್ 16 ಗೆ ಎಷ್ಟಿದೆ? 9,500. Age is yes. Estina hospital alle? Yes. Pain and suffering 25. Immunity 6%. ಯಾರು ಶ್ರೀಕಂಠೇಗೌಡರು ಬರ್ತಾರ? ಶ್ರೀನಿವಾಸ್ ಗೌಡ ಅಲ್ಲ, I will whether I can show his appearance. ಶ್ರೀನಿವಾಸ್ ಗೌಡ ಯಾರು? ಮಿಸ್ಟರ್ ಪಾಟೀಲ್ ಆರ್ ಶ್ರೀನಿವಾಸ್ ಗೌಡ, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಾಯರ್, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಆಗಿ ಬರ್ತಾರ? I can show his I can show his presence. I can disclose. Yes, sir. So and so, Bernard Council appearing for the claimant has contended that due to that extent, claimant has suffered head injury. He has examined neurosurgeon Dr. Satyanarayan MB as PW2. In his evidence, he has supposed that the claimant has suffered 35% disability. The tribunal has assessed whole body disabilities is 12%. Is on lower side. He is not stated that 11.66%. 1/3 ಇವರ ತಗೊಂಡಿರೋದಾ? Yes. He further contended that at the time of the accident, the claimant was earning 6 lakh per annum from agriculture income. The tribunal has considered monthly income of the claimant as 8,000 is on lower side. Lastly, he has contended that due to that extent, the claimant has suffered previous injury. He was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for announcement of compensation. Per contra, he or Srinivas Gowda, Bernard Council appearing for insurance company has contended that even though the claimant contended that the injuries suffered by the claimants are minor in nature, he has examined the doctor. Doctor has assessed the disabilities is 35%. Since doctor has not assessed whole body disabilities, the tribunal has rightly assessed that whole body disabilities as 12%. He further contended that even though the claimant has claimed that he was earning 6 lakhs per annum from agriculture income, due to that injury, there was no loss of income. Hence, the tribunal has to assess notional income. Accordingly, notional income assessed by the tribunal 8,000 is just and reasonable. We further contended that considering that injury suffered by the claimant, considering that evidence of doctor, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 26/10/2016 due to rash and negligent driving of driver of car bearing registration number KA 16 C4033. Due to that accident, the claimant has suffered the following injury. He has examined Dr. Satyanarayan, MV, neurosurgeon. In his deposition, he has categorically stated that the claimant has suffered 35% psychological disability. The tribunal is error in considering whole body disabilities by taking 1/3 since it is neurological disability. The method of whole body disabilities assessed by the tribunal is apparently error on face of record. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion that whole body disabilities can be assessed 18%. Even though the claimant has claimed that he was earning 6 lakhs per annum from agriculture. Due to that injury, he will not be suffered any loss since he can lose only supervising. Due to that, he will not suffer any loss. Under those circumstances, he will not get any loss in the agriculture income. Under those circumstances, the only notional income has to be assessed. To assess the notional income, consider that guidelines issued by Karnataka Legal Service Authority for the accident occurred in 2016. The notional income has to be considered as 9,500. At the time of the accident, he was aged about 42 years. The multiplier applicable to the age group is 14. Loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that wound certificate, I am inclined to enhance the compensation for pain and suffering from 25,000 to 40,000 Loss of immunity is 20,000 to 30,000. Loss of income during the later period has to be granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. The enhanced compensation amount carries 6% interest. Yes. Accordingly, the appeal allowed in court.
Number 65 adjourned, number 66. Because of the appellate matter, associate party.
Yes, party. Yes, Mr. Ravi Shankar, we have taken that notional income and disposed of. Yeah, ಯಾರ್ದ್ರಲ್ಲಿ ಅಲ್ಲ ಥ್ರೋಟ್ 6% ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಇದು ಕ್ಲೈಮೇಟ್ ಅಪೀಲ್ ಅಲ್ಲ ಅಲ್ರಿ ಇದು ಯಾವ ಕ್ಲೈಮೇಟ್ ಅಪೀಲ್ ಅಲ್ಲ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ excluding it. No, there is instead there is no any finding. They have not declared any law. And 6% enhanced ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
Even though payment appeal, court it will be awarded. That's why.
But yes, but if there is any law laid down, see earlier ನಾವೆಲ್ಲದಕ್ಕೂ 9 ಕೊಡ್ತಾ ಇದ್ವು. Justice Arvind Kumar has laid down the law. Then I said 6%. ಅದೇ ಆಕ್ಟ್ ಮೇಲೆ ಲಾ ಲೈಟ್ ಡೌನ್ ಮಾಡ್ತಾರೆ ಇದರಲ್ಲಿ. If it is said, see in view of that ಏನಾರ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ರೆ then yes correct, and you have brought to that note. Now I said normally what we are doing that has done it in your case in this objection. ಅಲ್ಲ ಅದಾಯ್ತು, ಅದು ಕನ್ಸಿಡರ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ. Why you have disposed in your absence, even if you are present also same thing, therefore I are. Yes. ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಡಿಸ್ಪೋಸ್ ಅದೇ yes ಅವರು ಸಿನ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಅದರಲ್ಲಿ interest awarded by the tribunal 9% is on higher side. Hence, in support of that, he has relied on judgment of this. Yes. Yes, Patil, what is this? Yes. What is the topic of objection? What you take notice to what is the topic of objection?
Rank of the parties, date of service, original certificate, provision of law.
Yes, we will grant time, we will comply. Yes, weeks time is granted in MFX to comply the topic objection. Yes, 2 weeks time is granted to comply the topic objection. Here substantial question of law frame ಮಾಡಿದಾರಾ? ಅಲ್ಲ ಅವ್ರದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಅಲ್ಲ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಮಾಡೋದಿಗೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ? Whether court has, whether the commissioner tribunal is justified in awarding the compensation particularly 9%. What is that 4A 3A Employees Compensation Act says? When deducting 50% income in the injured is not. Hello, what is that 4A3? 4A3. Direct employees in addition to the amount of the arrears pay, simple answer there at the rate of 12% per annum. Interest aste. Whether the commissioner tribunal is justified in deducting 50% of the income of the insured, ignoring the provisions of 4(1)(b. ಎಷ್ಟು ಡಿಡಕ್ಟ್ ಮಾಡಬೇಕು ಇಂಜುರಿಲಿ? ಇಲ್ಲಿ 50% ತಗೊಂಡಿದ್ದಾರೆ. ಸಿ ಇಲ್ಲಿ 50 ಡಿಡಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, 40 ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು. ನಿಮ್ದ್ರಲ್ಲಿ ಏನು ಇನ್ಕಮ್ ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್? Yes. Where is she? 230. You get her, we will dispose of them. Your objection may be that maybe delay calculate ಮಾಡಕಷ್ಟೆ. Then we will have it next week. You comply that also. Yes. 2 weeks time is granted to comply that office objection. MFX up. Yes. What is this, Mr.? Yes. 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 Where is that? On what ground? Why insurance policy illa? Pain recovery ಆದ್ರೂ ಕೂಡ ಓನರ್ ಅಷ್ಟು ಪೇನ್. Yes. The tribunal ಅಲ್ಲಿ ಏನು ಪೇನ್ ರಿಕವರಿ ಮಾಡಿದಾರಾ? ಇಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. Yes. 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 Death is on 11th. Hello, yeah, day time. Yes. 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 ಎಲ್ಲಿದೆ? Yes. What is that FIR? Yes. Complaint is not against you. FIR is also not large against you. That will come later. Pursuant to that, complaint is also not against you. FIR is also not filed against you. Exhibit P. Yes. Column number. Yes. 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 P4 postmortem report. P5. Request ಏನಿದೆ? Same. ಅದೇ ಬೈಕ್ ಇಂದ ಆಯ್ತು. ಆಮೇಲೆ ಆಯ್ತು. Yes. Exhibit. Yes. Yes. ಯಾರು ಕುಮಾರ್? Yes. Yes. It's pending. Yes. Okay. Yes. 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 161 ಯಾವತ್ತು? 161. 161 ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವತ್ತು? 38. ನಿಮ್ ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡೋದು ಅವತ್ತ? ಅದೇ ಆಮೇಲೆ ಸೀಸ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ. Yes. ಅದು ನೆಕ್ಸ್ಟ್ ಡೇ, ಏನ್ ಭಾರಿ ಏನ್ ಲೇಟ್ ಅಲ್ಲ. ಅಲ್ಲ ಚೇಂಜ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಬಿಟ್ವೀನ್ 1 day. Yes. Who are the witness to that? ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. Yes. Sketch has been drawn on the same day. Same day ne ಮಾಡಿರ್ತಾರೆ on the basis of the statement given by the witness. ಅಲ್ಲೇನ್ ವೆಹಿಕಲ್ ಏನು ಇರೋದಿಲ್ಲ. It is not their case, hit and run also. ಒಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದ PW1. Who is PW2? ಒಬ್ಬರೇ ಮಾಡಿರೋದಲ್ಲ. ಆಯ್ತು, she is not an eyewitness. What is the relevance? Yes. ನೀವು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ? ಓನರಾ? RW2 ಓನರ್ ಏನ್ ಹೇಳಿದಾನೆ? ಅವನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾನೆ. RW2 ಏನ್ ಹೇಳ್ತಾರೆ? ಏನ ಓನರ್ ಏನ್ ಹೇಳ್ತಾರೆ ಬೇಕಲ್ಲ ಫಸ್ಟ್. ನೀವೇ ಒಪ್ಕೊಬಿಟ್ರೆ ಮತ್ತೆ ಬಕ್ಕಿದಲ್ಲಿ ಯಾಕೆ ನೋಡಕ್ ನಾವು ಸುಮ್ಮನೆ. Respondent only the above. ಮತ್ತೆ ನೀವು ಆಕ್ಸಿಡೆಂಟ್ ನಮ್ ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲಲ್ಲ. ನೆಗ್ಲಿಜೆನ್ಸ್ ಡಿನೈ ಮಾಡಿದ್ದೀರಾ, ಅಲ್ಲಿ ವೆಹಿಕಲ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಎಲ್ಲ ಹೇಳಿದೀರಾ, ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು, ಬಟ್ ನಂದಲ್ಲ ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂತ ಹೇಳಿದೀರಾ. ವೇರ್ ಇಸ್ ಯುವರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್? ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅಂತ ಕಂಟೆನ್ಷನ್ ಡಿನೈ ಮಾಡದ್ರಿ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆತ? ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? ಏನ್ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಅದನ್ನ ಹೇಳ್ತಾರೆ. ಆಕ್ಸಿಡೆಂಟ್ ಒಪ್ಕೊಬಿಟ್ಟಿದ್ದೀರಲ್ರಿ ನೀವೆಲ್ಲ ಕಡೆ. Yes, you see that return statement. If that accident in question is caused mainly due to that rash and negligent, unmindful act of the petitioner. In case ಏನು ಅಂತ ಅಂದ್ರೆ ನಂದೇನ್ ತಪ್ಪಿಲ್ಲ, ಅವ್ರ ತಪ್ಪು ಅಂತ. ನಮ್ ವೆಹಿಕಲ್ see as on that day, your vehicle was there on the spot, you are not denied. You said that he himself has skid and fall. In Gadi nodi hedri bidirbodu anta nim dakka. But in Gadi avatti see from the beginning it is argument of the Sidramaya, your vehicle was not there on that day. But by seeing your return statement on this thing, your vehicle was there. But it has not hit that scooter. Is it not? Then we will go to the IME report. Wordings alla. That is the main. Wordings ಏನilla. ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಕೇಸ್ ಹಾಕ್ಸಿದ್ದೀರಾ. ಹೆಂಗ್ ಬಿದ್ದಿದ್ರೋ ಗೊತ್ತಿಲ್ಲ. ಈಗ ನಿಮಗೆ ಯಾವಾಗ ಇದು ಬಂತು ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಈಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಅಂದ್ರೆ ಯು ಆರ್ ಚೇಂಜಿಂಗ್ ಇಟ್ ವರ್ಷನ್. We don't know, your vehicle may not be involved, but you colluded with that claimants. You have said that yes, my vehicle is involved in the tax debt. Drafting draft all evidence has to be accepted. Allah, show me that on that day your vehicle was not there anywhere in that statement. It is not your case at all. In your evidence also. Deny ಮಾಡಿರೋದು ಏನು ಅಂತ ಅಂದ್ರೆ negligence has been denied. His own negligence accident has occurred. That is your case. It is not your case that my vehicle has been wrongly implicated. In his FIR complaint, my vehicle was not there. In the spot also, vehicle was not there. Now they have made a false claim implicating my vehicle. No, that's what that I'm saying. On the spot, your vehicle was there on that day. Is it not? Is it not? Now, what is your case then? ಆಯ್ತ್ರಿ ನಿಮ್ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಇತ್ತ ಇಲ್ವಾ ಈ ಓನರು ಯು ಹ್ಯಾವ್ ಟು ಸೇ see you said it is in negligence accident has happened ಅಂತಂದ್ರೆ how do you know that? Sir, that cannot be an objection. Yes. Drove the vehicle in the rash and negligent manner. The vehicle was skipped and so hospital. Petitioner fell down fast and injury. Shifted to the hospital. He died on the way. This is regard father of the petitioner has given a complaint before the concerned police. That is all that either on your assurance that ಆಯ್ತು ನಾನು ಏನೋ ದುಡ್ಡೆಲ್ಲ ಕೊಡ್ತೀನಿ ನೀವು ಈ ತರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿ ಅಂತ ಹೇಳಿರ್ಬೋದು ಒಂದು, ಅಥವಾ ನೀವಿಬ್ರು ಕೊಲೀಡ್ ಆಗ್ಬಿಟ್ಟು ಆಯ್ತು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ನಂದು ಹೆಂಗು ಇನ್ಸೂರೆನ್ಸ್ ಇದೆ ಕ್ಲೈಮ್ ಮಾಡೋಣ ಅಂತ ಹಾಕಿರ್ಬೋದು. ಆಮೇಲೆ ಅಲ್ಲಿ ಗೊತ್ತಾದ್ಮೇಲೆ ಚೇಂಜಿಂಗ್ ದಟ್ ವರ್ಷನ್ ಅವರು ನೌ ದೇ ಆರ್ ನಾಟ್ ಸಪೋರ್ಟಿಂಗ್ ಯುವರ್ ಕೇಸ್ ಕ್ಲೈಮೇಟ್ಸ್ ಯಾಕೆಂದ್ರೆ ದೇ ಆರ್ ಬೆನಿಫಿಷಿಯರಿ. Yes. No, all that can be considered for negligence. Not for that your vehicle is not at all involved because you yourself have admitted. Where is that IMA report? Left side door dented. KA 17 ಯಾರ್ದದು? ನಿಮ್ದು ಮತ್ತೆ ವೆಹಿಕಲ್ ತಾಗಿಲ್ಲ ಅಂದ್ರೆ ಡೆಂಟ್ ಮಿರರ್ ಎಲ್ಲ ಯಾಕೆ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ? ಅವ್ನ್ ಸ್ಕಿಡ್ ಆಗಿದ್ ನೋಡಿ ನಿಮ್ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ. Yes. 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 Just because that nothing has been stated in that measure, we cannot discard all this evidence. And also your written statement has not denied that your vehicle was not there on the spot. It was there. It was been seized. Yes. Yes. No. That is what that. After that, it has been seized. No. All that for what purpose? For negligence. No. That you have not denied. That you have not denied in the written statement. That cannot be. Even it is not in your evidence also. Only thing is whether rider of the motorcycle is also involved any contributory negligence. Yes, he is not an eyewitness, and that somebody has telephoned him, and that I will consider. It is not in a criminal case. See, you could have denied in that written statement. Therefore, I have taken that taken to you to that written statement and your evidence. There, the court has changed the entire that version. Till then, I am under the impression that yes, your vehicle has been fixed. Then I come to the conclusion that it is not fixed. Now that Sidramaiah is making and improving his case. Yes, that is not that you are making an attempt to improve your case, which is not supporting that document. Yes. Where is that this thing? Sketch. Yes. Which is that bike? K14. ನಿಮ್ದು ಯಾವ ಊರಿದು? ಯಾವ ಕುಂದೂರು ಕಡೆಯಿಂದ ನೀವು ಬರ್ತಾ ಇದ್ರಿ, ಅವ್ರು ದಾವಣಗೆರೆಯಿಂದ ಬರ್ತಾ ಇದ್ರು. Then it shows your extreme right. Yes. Yes. What is that investigation officer has given evidence? CW? You have not examined that driver. Owner driver. Investigation officer ಏನ್ ಹೇಳ್ತಾರೆ? ಸೀಸ್ ಮಾಡಿದೀನಿ ಅಂತಾರೆ. ಸ್ಥಳ ಪಂಚನಾಮ ನಾನು ಮಾಡಿಲ್ಲ, ಕೇಸ್ ಸಾಕ್ಷಿದಾರರು ಒಂದರಲ್ಲಿ ತೋರಿಸಬಹುದು, ಆದರೆ ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಎಂದು ಹೇಳ್ತಾರೆ. ಏನ್ DL ಇಲ್ವಾ ಅವ್ರದ್ದು? ಅಲ್ಲ ಸರಿಗೆ ಅವ್ರಿಗೆ DL ಅದೇ ಯಾರ? ಅವರೇನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. No, it is who has examined him? ಓನರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದ, ಪೊಲೀಸ್ನವ್ರು ಕರ್ಕೊಂಡು ಏನಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಪೊಲೀಸ್ನವರು? He is your witness. Yes. What is that considered? How the finding of the tribunal? You have also filed an appeal for enhancement. Now that what is that law on that point when that owner himself has appeared before the court? Shamana case is it owner or a claimant? See that. See Shamana case. It is by the claimant. It is by the claimant. What do you? Huh? No. The third parties ಬಂದಾಗ ಓನರೇ ಕೋರ್ಟ್ ಮುಂದೆ ಇದ್ದಾಗ what is that relief you can be granted to that this thing? ಅದರ ಚಾಮಣ್ಣ ಕೇಸಲ್ಲಿ ಯಾರೋ ಹಿಂಗ್ ಹೇಳಿದ್ರು. I think I have seen it is by the it is appeal filed by the before the Supreme Court is that claimant, is it not? Then no, see why they said owner is not available, but yes. No, that in your appeal you have deposited some amount in your case. ಅಷ್ಟೇ 25. 50% award amount deposit ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಏನಿಲ್ವಾ ನಿಮ್ದ್ರಲ್ಲಿ? ಬೇಡ, ಬೇರೆ ಎವಿಡೆನ್ಸ್. This is the first appeal. I can give a finding. That is, it is not a mandatory in that Motor Vehicles Act. Motor Vehicles Act ಅಲ್ಲಿ see ನೀವು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ರಿ, ಐ ವಿಟ್ನೆಸ್ ಏನಕ್ಕೆ? Now, you yourself has not denied that your vehicle was not involved, implicated. It is not your case. Negligence ಬಗ್ಗೆ, negligence has to be proved by the claimant. See, court has to give an evidence on the basis of that materials available on that negligence. So, see, that they have said Investigation officer has been examined by. Yes, he had the person who has changed that version. You examine him. Why you? No, he said he has received the phone call from whom? You have not examined that person. Person who has what is his name? Kumar. You examine the Kumar. No, that is the case is pending there. There. Cycle between. No, what is the stage of the criminal case? What is the difference? Difference in the criminal case? ಅಪಘಾತಕ್ಕೆ ಗುರಿಯಾಗಿರುವ ಅಂದ್ರೆ ಅಪಘಾತಕ್ಕೆ ಇನ್ವಾಲ್ವ್ ಮಾಡಿರೋ ವೆಹಿಕಲ್ ನಂದು, ನಾನೇ ಓಡಿಸ್ತಾ ಇದ್ದೆ ಅಂತ ಅಂದ್ರೆ ಇಟ್ ಆಲ್ ಶೋಸ್ ಆಸ್ ಆನ್ ದಟ್ ದಿಸ್ ವೆಹಿಕಲ್ ವಾಸ್ ದೇರ್, ಬಟ್ ವೆದರ್ ಯುವರ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ವಾಸ್ ದೇರ್ ಆರ್ ದಟ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಫ್ that has to be proved. But the eyewitness which you have examined, she is not an eyewitness to that accident. Then some extent you see that you have went down. See, Iva has been examined. He is not an eyewitness. See, eyewitness officers are available. That is also that complainant which is given by your father. He has not been examined. Kumar, who is there, he has not been examined. See whether, see your case, whether by seeing that opposite vehicle, suppose if your vehicle was skid and fell down, then your vehicle, that auto has been hit. That may be the chance. Then Kumar has to say, sketch is not that documents that Supreme Court said. See, if eyewitness has said, then we can be relied on the sketch. No. No. Sketch will be prepared after the accident. Vehicle was not there in the spot. Then why? Yes. Then complaint has not been registered against that this thing. Only after the charge sheet. Yes, we'll send it back. You examine that person. Yes, we'll consider your submission of. Pancha witness is no, Mr. This has been, police has not seen that. It has been recorded on the basis of the Pancha witness. They have not been examined in this case. That is what that. Alre, avunu examine ಮಾಡಿದಾಗಲೇ ಗೊತ್ತಾಗತ್ತಾನೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾಗ. Yes. No, the charge sheet it is pending. Criminal case. ರೀಸೆಂಟ್ ಆಗಿ ಯಾವ್ದೋ ಒಂದು ಇದೆಯಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಕೆನಾಟ್ ಬಿ ರಿಲೈಡ್ ಅಂತ ಎಲ್ಲ ಐತಲ್ಲ. ಯಾವ್ದ್ರಿ ಅದು? ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ನಾಟ್ ಓನ್ಲಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಪ್ರೂಫ್ ಅಂತಿಲ್ಲ ಮೊನ್ನೆ. ಯಾರ? Yes. Para 25. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ FIR ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಡಿಫಿಷಿಯನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೈಕೋರ್ಟ್ ಅವ್ರು ಹೇಳಿಲ್ಲ, ದೇರ್ಫೋರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದಿಸ್ ಇಸ್ ನಾಟ್ ದಟ್ ಸಿನ್ಸ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದ ಚಾರ್ಜ್ ಶೀಟ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್. No. See, his vehicle was there. Involvement of the vehicle, there is no dispute because he has also not disputed. Now the question, negligence has to be proved by you. How you have proved that negligence? What improve? He will what improve that situation? No. I will give a finding that involvement of the vehicle is there is no dispute. Only thing is negligence, since sufficient material for evidence of the complainant and eyewitness is there, they are not examined. Only for the purpose of the negligence. No, there may be, but he has a complainant. He has given a complaint. Then he has to prove that whether that Kumar has given that statement that it is a self-fault, that he has to say. Then Kumar has to be examined. Kumar has accompanied by that this thing. He is an eyewitness. Then Pancha witnesses has to be say yes. Avren bada, ಅವರಲ್ಲ ಪಂಚ ವಿಟ್ನೆಸ್. ಯಾಕೆಂದ್ರೆ ಪಂಚ ತಯಾರು ಮಾಡಿರೋದೇ ಅವ್ರ ಮೇಲೆ, ಪೊಲೀಸ್ನವರು ಅವರೇ ಹೇಳಿರೋದು ಹೌದು ಈ ವೆಹಿಕಲ್ ಹಿಂಗ್ ಬರ್ತಿತ್ತು ಹಿಂಗ್ ಬರ್ತಾ ಇತ್ತು ಅಂತ. They are the yes 230 yes involvement of the vehicle. I will give the finding. Yes 230 I will dictate.
ಕೇಸ್ ಇದು.
So they had bought one coffee estate and all. Okay. And she says she's very comfortably placed there. She stayed for a lot of years in Madras, how many years? Yeah, and my parents, all of us. I don't know what happened to you. I was not married. No, she was
Serial number 67 is the Siddaramaiah for appellate connected matter. R. Shashidhara for Mahesh
Yes, yes, your presence, Shashidhar is there. Yes. Yes. Hmm. Yes. Yes. Hmm. Eyewitness has been there. Eyewitness ಇದ್ದಾಗ first information report that is not the problem. Negligence. Even quantum also let it be instead of here we are giving. See, Sidramaya, learned counsel appearing for owner of the offending vehicle has contended that the accident was occurred on 29/8/2017 at 9:30 a.m. Immediately after, deceased has been shifted to hospital. Therein, he has succumbed to that injury at about 11 p.m. on 29/8/2017. At about 12 a.m., the father of the deceased has given a complaint as per exhibit one. The accident has occurred due to self-fall. Pursuant to that, the police has registered an FIR, exhibit P2, stating that the accident is occurred due to the self-fall. There is no mention of offending vehicle was involved in the accident. He further contended that even as per exhibit P5, P4 postmortem report, it is mentioned that the accident is due to self-fall. As per exhibit P5, P4 inquest report. As per P5 postmortem report, it is mentioned that death is due to self-fall from motorcycle. Even statement of 3 witnesses has been recorded to that effect. Therefore, it is very clear that the offending vehicle was not involved in the accident. The tribunal is error in held that driver of the auto is negligent in causing that accident. He further contended that the first time in 161 statement given by the complainant, that is father of the deceased, has stated that the accident is occurred due to stated that the driver of the offending vehicle was dashed against the motorcycle due to impact. The rider of the motorcycle has fell down and suffered injury and second death injury. Thereafter, on 30th 8 2017, the vehicle has been seized from the house of the owner. The sketch and measure has been drawn on 30th. On 30th. Even seizure on 30th. Pursuant to that 161 statement, the police has thereafter he has given a 161 statement as per exhibit P3. Thereafter, the police has drawn a mahazur and the sketch on 29/8/2017. Even the panchas, the mahazur witness has also not been examined. Even the complainant is also not examined. As per the complainant, one Kumar, who is an eyewitness to the accident, he is also not examined. Only on the basis of that, police has filed a charge sheet against that offending vehicle. The tribunal has held that driver of the auto is negligent in causing the accident. There is no proper evidence to prove that there is a negligence on the part of the driver of the bus, the driver of the car. Lastly, he has contended that even in respect of criminal case is concerned, the matter is pending before the criminal court. The owner of the owner cum driver of the offending vehicle was contesting the matter before the criminal court. Therefore, he sought for allowing that appeal filed by the insurance company, filed by the owner. Shri Shashidhar, Learned Counsel appearing for claimant has contended that the accident is occurred due to the negligence of driver of the goods auto bearing registration number KA17A1699. Pursuant to that summons issued by this court, by the tribunal, the owner cum driver has appeared before the tribunal, has filed in a written statement. Nowhere he has denied that his vehicle was not involved in the accident. Even he has been examined as RW2. RW2, in his evidence, he has not denied that his vehicle was not involved in the accident. Therefore, he contended that the driver of the offending vehicle was negligent in causing the accident. He further contended that the father of the deceased, who is a complainant, is not an eyewitness. On the information received through phone from Kumar, he has given a complaint. Later, he has come to know that the accident is occurred due to the negligence of driver of the auto. He has given a further statement before the police under section 161. On that basis, subsequently Kumar has said, subsequently I said, yes. On the basis, the police, after thorough investigation, has filed a charge sheet against the driver of the offending vehicle.
I'm in the other court for 5 minutes.
It is very clear from the Mazur and charge sheet, the Mazur and that sketch, that driver of the offending vehicle has driven that vehicle in the extreme right side and dashed against that motorcycle. Due to impact, the deceased fell down and suffered injury and succumbed to that injury. The tribunal, he further contended that even while after that vehicle has been, even when he has sought for releasing of the vehicle, he has given a indemnity bond exhibit P10, P11, where he has admitted that the vehicle was involved in the accident. The tribunal, after considering the evidence of the parties, has rightly held that driver of the offending vehicle is negligent in causing the accident. Hence, he sought for dismissal of the appeal filed by yes. He is held that, contended that, sought for dismissal of the appeal filed by the owner. Lastly, he has contended that the compensation awarded by the tribunal is on lower side. Since the claimant is in a third party, even if driver of the offending vehicle was not having valid driving license, the insurance company has to pay that compensation with liberty to recover from the owner of the offending vehicle. Shri O. Mahesh, learned counsel appearing for the insurance company, has contended that as on the date of the accident, driver of the offending vehicle was not having valid and effective driving license. Since he has violated the policy condition, the insurance company is not liable to pay the compensation. Yes, Mahesh, any further argument? Unmute Madi.
Exhibit P1, my lord, the complaint by the father. There, my lord, said kid and fell down.
That all I have considered by the argument of the owner.
Then, my lord, the evidence of, my lord, the owner is collusive.
That's what. Now I am sending back that matter.
Yes.
I will remand the matter. Since they have not examined that complaint, yes, master witness is also not examined.
Please.
Even for liability is also kept open.
Please, please.
Contended that insurance company is not liable to pay that compensation. Is also further contended that the offending vehicle was not involved in the accident. It is very clear from complaint as well as FIR. Heard the learned counsel for the parties. Arose judgment and award and original records. The case of the complaints that on 29/8/2017 at about 9:30 a.m. deceased Siddhappa, after dropping Siddhappa, was proceeding in his motorcycle bearing registration number KA 14. Siddhalingappa, Antarhita Liberal Prime Liberally, judgmentally. See that para 3. It is what is there in that judgment. I am dictating this. Yes. If you want to get any clarification, you have to get it rectified in that judgment. Yes. Otherwise, judgmental one, non-judgmental one, unless it is filed an application and clarified. Yes. Traveling in motorcycle bearing registration number KA14 EG 1577 on Kundur Davangere Road. When they reach near Kenegalahalli village of Pannali Taluk, the rider of the goods auto bearing registration number KA17 A1699 coming from opposite directions has dashed against the motorcycle. Due to impact, the deceased just fell down and suffered from injury, and he has been shifted to Chigattigere District Hospital. Chigateri District Hospital. Later, he has succumbed to the injury. To prove the case, the claimant has examined PW1. First claimant has examined PW1, Srimati Deepa. She has reiterated statement made in the claim petition. She was not an eyewitness to the accident. As per the case of the claimant, one Sri, what is the name of your father who has complained? One Sri Madhavaya, who is a Mahadevaya, who is a father of the deceased, has given a complaint. As per the complaint exhibit P1, he has stated that his son Siddhalingappa has fell down from his bike. He skid and fell down from his bike. Pursuant to that, the police has registered an FIR as per exhibit P2. Even in the inquest report exhibit P4, it has been mentioned that Siddhalingappa was died due to skid of his motorcycle. Even for the postmortem report exhibit P5, it has been written that he fell down from the scooter by the bike.
In the
Even
inquest also, my lord. In the inquest report also it is mentioned.
even that witness to that PM reports, there are 3 witnesses to that PM report. They have also mentioned that inquest report, PM report, inquest report. Inquest report. In inquest report also, exhibit P4, it has been mentioned that P5 is a PM report, Mr. P4 ಏನು inquest report is the P5, P4. P5 is ಉಲ್ಟಾ ಹಾಕಿದಾರೆ ಹಂಗಾರೆ
P5, my lord. Paragraph 11, my lord. Paragraph 11.
that is wrong. ಇದರಲ್ಲಿ P5 is inquest report.
Yes, my lord.
P? Yes. Even in postmortem report, it is mentioned that he fell down from the scooter. Even as per inquest report, exhibit P5, it has mentioned that he has fell down from the bike.
1, 4 and 11, my lord.
Yes. And also statement of 3 witnesses has been. Huh? 4 witnesses has stated that fell down from the bike. In the first time, when the police has recorded 161 statement, the complainant has mentioned that later he has come to know that his son was died due to the accident. The driver of the goods auto has dashed against the motorcycle. On the basis of that, the police has filed a charge sheet. The complainant as well as the eyewitness Kumar has not been examined. Even the police has drawn a mahzur. The mahzur witnesses is also not has been examined. That is a difference. The problem is you have not denied involvement of the vehicle. Deny adra matra valla, you have to see that all discrepancies. There is no denial. The mahzur witnesses is also not examined. But only on the basis of the sketch, mahzur and charge sheet has come to the conclusion that the offending vehicle, the driver of the offending vehicle was negligent in causing the accident. Since it is a burden on the claimants to prove that negligence is on the offending vehicle. To prove the same, they are not examined the eyewitness. The PW1, she is not a witness to that accident. Therefore, not to that extent to the witness. Next paragraph. In respect of involvement of the vehicle, KA 17A 1699 is concerned, there is no dispute since the driver come owner of the offending vehicle was not, he has appeared before the tribunal, has filed an objection. He has not denied that his vehicle was not involved in the accident. And in his evidence also, not denied that his vehicle is not involved in the accident. Therefore, involvement of the offending goods auto bearing registration number 17 KA 17A 1699, there is no dispute. Only dispute in respect of the negligence is concerned. The claimant, it is a burden on the claimant to prove that negligence, even though the complainant and eyewitness and there is a bunch witnesses are there, they have not been examined. Under these circumstances, the matter requires to be remanded back to the tribunal for fresh consideration, giving an opportunity to the claimants to prove his case for negligence. Accordingly, the appeal is allowed. In respect of quantum and liabilities is concerned, it is kept open for the tribunal to reconsider. Accordingly, the appeals are allowed in part. Judgment and award passed by the tribunal is set aside. In respect of involvement of offending vehicle KA 17A 1699 is concerned, the finding of the tribunal is confirmed. In respect of negligence and quantum and liabilities is concerned, the tribunal is directed to reconsider after giving an opportunity to all the parties to adduce all evidence. Accordingly, the appeals are disposed of. Yes, you want any time limit? Amount in deposit is transferred to the tribunal. 25,000 ರೂಪಾಯಿ ಏನಕ್ಕೆ FT ಆಗ್ತಿರೋದು? ನೀವೇನಾದ್ರು 50
Date for appearance.
parties are directed to appear before the tribunal on July 28th without any further notice. The tribunal is directed to dispose of the appeal within 6 months from date of appearance of parties.
Please.
Yes, yes, where is the other side? Yes, Ravi, which is your matter? Yes, Sridhar, you have any other matter? Which is yes, serial number 59. ನಿಮ್ದು ಯಾವುದು ರವಿ? ಯಾರಿದ್ದಾರೆ ನಿಮ್ಮ ಅಪೋನೆಂಟ್? Yes. ನಿಮ್ದು ಏನ್ ಕೇಸು? That is only that Gopal Kishan case has been considered by the Supreme Court. That only we have to read. Kishan Gopal. Yes, other than 5 minutes mugisbitತೀನಿ. Yes. Padi. Serial number 59. Yes. 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 Where is that? Which is that division bench? What is 2014? ಏನಿದೆ ಅದರಲ್ಲಿ? What is the say? Allow ಮಾಡಿ. Then Supreme Court judgment ಇದೆ. ಅಲ್ಲಿಗೆ ಎಷ್ಟು ಬರುತ್ತೆ ಕಿಶನ್ ಗೋಪಾಲ್ ಆದ್ರೆ? 5 ಲಕ್ಷ ಬರುತ್ತೆ. That will be ಆಮೇಲೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ರಿಟರ್ನ್ ಆಗುತ್ತೆ. 5,41,000 ಅಲ್ಲಿಗೆ 60, 70, 80,000 ಕಡಿಮೆ ಆಗುತ್ತೆ. 80,000 ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್. Yes. ಕಿಶನ್ ಗೋಪಾಲ್ ಕೊಡ್ತಿದ್ದೀವಿ. So and so learned counsel appearing for insurance company has contended that ಅಲ್ಲಿಗೆ ಎಷ್ಟಾಗುತ್ತೆ? Recent decision of the court will bring this is also followed the same. No. What is the multiplier which is applied? Yes. Now that age of that under that Workmen Compensation Act, they have applied that age. No, that was the law earlier. Even in major also, that ಅವಾಗ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏಜ್ ಆಫ್ ದ ಪೇರೆಂಟ್ಸ್ has to be younger parents has to be considered. Now that law has changed. Minor ಆದ್ರೂ ಕೂಡ the tribunal will consider 18 that for the minor there is a provision under the workman compensation. Why can't you apply that? See, analogy is death persons has to be considered for multiplier. Now that law laid down by the Supreme Court is that person who has died, that has to be considered. Now you are that formula which is getting for majors for 18 years. Minor we have a formula under that workman compensation. ಇದರಲ್ಲಿ 15 ಹಾಕಿದಾರಾ? ಅಲ್ಲಿ ಸರಿ ಆಗುತ್ತೆ. ಟ್ರಿಬ್ಯುನಲ್ 17 15 ಹಾಕಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? 4 ಲಕ್ಷ ಬರುತ್ತೆ. ಸರಿ ತಾಳಿ. Yes, yes. See, so learned counsel appearing for the insurance company has contended that at the time of the accident, deceased was aged about 6 years. While assessing loss of dependency, the tribunal, instead of considering the age of the deceased for assessing the multiplier, they has considered that age of the mother. As per the Workman Compensation Act, for the age of the deceased 6 years, the multiplier applicable is 15. We further contended that ಅಲ್ಲಲ್ಲ ಫ್ಯಾಕ್ಟರ್ಸ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಕೊಡಿ, ಫ್ಯಾಕ್ಟರ್ಸ್ ಅಲ್ಲ ರೀ ಮಲ್ಟಿಪ್ಲೈ ಅಲ್ಲಲ್ಲ ಏಜಿಗೆ ಯಾವ್ದೊಂದು ಮಲ್ಟಿಪ್ಲೇಯರ್, ಆ ಮಲ್ಟಿಪ್ಲೇಯರ್ ಅಲ್ಲ ವರ್ಕ್ಮೆನ್ ಕಾಂಪನ್ಸೇಷನ್ ಆಕ್ಟ್ 163 ಕೆಳಗಡೆ ಇರ್ಬೇಕು. 163 ನಾಟ್ ದಟ್ 163 ನಾಟ್ ವರ್ಕ್ಮೆನ್ ಕಾಂಪನ್ಸೇಷನ್ 163 ಕೊಡಿ ಮೋಟರ್ ವೆಹಿಕಲ್ ಸರ್. ಅಲ್ಲ ರೀ ಯಾವ್ದ್ರಲ್ಲ ಇದೆ ರೀ 15 ಮಲ್ಟಿಪ್ಲೇಯರ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು? ಎಲ್ಲ ಇದೆ ರೀ. ಐ ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ 15 ಮಲ್ಟಿಪ್ಲೇಯರ್ ಐ ಹ್ಯಾವ್ ಸೀನ್ somewhere minor ಇದೆ. See, up to 15 years multiplier is 15. It is there, Mr. Scheduled 163A. It is there. I have seen somewhere. You regular appear, you are all has to assist the court. See, when there is no any, if the act is not provided any that multiplier, then that law says nearest act has to be. If there is no provision under the Motor Vehicles Act, nearest act workman compensation. Here there is a provision. Even though it is 163A, since there is no any such judgment on that, we can consider that. Yes. He contended that even as per the apex court judgment in Sarala Varma, the multiplier has been assessed for the major person. ಅಲ್ರಿ ನಿಮಗೆ 18ಗೆ ಅಥವಾ 25 ಇಯರ್ಸ್ಗೆ 18 ಮಲ್ಟಿಪ್ಲೇಯರ್ ತಗೋಬೇಕಂತ ಎಲ್ಲ ಇದೆ? ಯಾವ ಲಾದಲ್ಲಿ ಇದೆ? ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? 163 ಏನಿದೆ? ಅಪ್ ಟು 15 ಇಯರ್ಸ್ ಮಲ್ಟಿಪ್ಲೇಯರ್ 15 ಇದೆ ರೀ ಇದ್ರಲ್ಲಿ. ಅಲ್ರಿ ನೋಡ್ರಿ ಅಂಡರ್ 166 ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಮಲ್ಟಿಪ್ಲೇಯರ್ 15 to 28 years ಗೆ 25 years ಗೆ ಮಲ್ಟಿಪ್ಲಿಯರ್ 18 ಅಂತ ಎಲ್ಲಿದೆ judgment? There is no law, is it not? It has to be assessed on the basis of that. Then we have to be considered on the basis of some materials. Now at least we have that. See, if there is a law, then it's, if there is no law on that point, the court has to assess on the basis of the circumstances. Yes. Since, as per the judgment of the apex court, in respect of multiplier is concerned, apex court in case of Sarala Verma, as for the major person, the multiplier has been considered from the age of 15 years under those circumstances. He contended that for the person below 15 years, the multiplier has to be considered 15 by considering that second schedule under section 163A. Lastly, he has contended that ಅದರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ 5 lakhs plus 50,000 ಏನಕ್ಕೆ 450 plus 50 ಏನಕ್ಕೆ 20,000 pain and agony. Yes. 30,000 to 450, 50,000 under the conventional act. ಅಷ್ಟೇ ಹೇಳಿದೆ. Medical expenses ಬರಲ್ಲ. Yes. Medical expenses. ಅಲ್ಲ pain and agony ಬರಲ್ಲ 20,000. He further contended that the compensation awarded by the tribunal for pain and agony of rupees 20,000 is contrary to judgment of apex court in Kishan Gopal. Hence he sought for allowing that appeal. For contra, Shri Shashidhar Learned Counsel appearing for the claimant has contended that tribunal has rightly assessed the loss of dependency after following the judgment of apex court in Kishan Gopal. Since deceased was a minor, the age of the mother has been considered and loss of dependency has been rightly assessed. ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲ ಪಣಯ ಸೇತಿಲ್ಲ ಏಜ್ ಆಫ್ ದ ಡಿಸೀಸ್ ಜಸ್ಟ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ ಪಣಯ ಸೇತಿಲಿ ಇರ್ಬೇಕಂತ ಕಾನ್ಸೆಪ್ಟ್ ಯಾವ್ದು which is the paragraph? Sarala Verma discuss ಮಾಡ್ಬಿಟ್ಟು they said then she contended that the compensation awarded by the tribunal is just and reasonable. No, that is when. Where is that Mullalal? Put it, then we will see. Then we'll consider tomorrow. We'll consider that which is that multiplier aspect. Otherwise, it will be that binding for other tests also. Allah, what is the age of the mother is there? No, this is Allah. Put it as a division bench judgment. Put it. ಎಲ್ಲಿದ್ದಾರೆ para 8 ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ coordinate bench of this court relying on so and so towards the loss of dependency death of the boy who was aged about 6 years mother age ಏನು ಹೇಳಿಲ್ಲ how can this can be considered you get that judgment you'll see that there also if the division bench said even though mother age is that multiplier applicable to that more than that if it is taken 15 then that is applicable division bench you produce that division bench judgment if even the multiplier of the mother if you take if it is more than 15 then also tribunal division bench has taken 15 then I can easily follow and dispose of instead of considering all this. Yes, any cases which is decided by the division bench you produce then it is younger age of the parents whether after that Supreme Court judgment earlier even for majors also younger age then the Supreme Court has taken a decision that no not that age of the parents age of the deceased then same principle when that Kishan Gopal has been decided there was no Supreme Court judgment that deceased age has to be considered then that may be the intention of the judgment After that Supreme Court judgment, that is Kishan Gopal judgment adre, then Supreme Court is very clear that in case of the minor is parents has to be considered. That has to be distinguished. Yes. When that Supreme Court has held that age of the deceased has to be considered. ಆಮೇಲಿಂದ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಮೇಲೆ ಹೇಳಿದ್ರು ಕೂಡ in case of minor parents has to be considered, then you have to follow the Supreme Court. Yes, you highlight that. Yes, next week. Yes. You also get that judgment. Yes. 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 ಎಷ್ಟು ಮಾಡಿದಾರ ಅವರು ಯಾರು ಅಸೆಸ್ಡ್ ಅಂಡರ್ ದಟ್ ನೋ ಅಲ್ಲ 9 ಲಕ್ಷ ಮಾಡಿ WC ಆಕ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿ ಅದನ್ನ ಕಳೆದು ಬಿಟ್ಟು WC ಆಕ್ಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಕಟ್ಟಬೇಕು, ರಿಮೈನಿಂಗ್ ಓನರ್ ಕಟ್ಟಬೇಕು ಅಂತ ಇರೋದು ಜಡ್ಜ್ಮೆಂಟ್. ಆತರ ದಟ್ ಇಸ್ ವೇರ್ ಇಸ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್? Yes. No, if it is an motor vehicle policy, then it is covered. Only in case of that workman compensation, then only that Supreme Court, the High Court, Supreme Court said you calculate both. Insurance company policy irad astuk matra, remaining you by the owner. Yes. WC Act. Owner. But here that he is saying that policy is their motor vehicle. The records alone. Iga, one thing, Mr. If you want to produce the policy, you can produce here also by. If really policy is not there, well, if it is, let us see, mark. Copy of the notice, MOP, so also MOP. Produce madangilla. What is that MOP ಅಂದ್ರೆ ಏನದು? Idea policy. Copy is there. ಅದೇ ಒಂದು ಪೇಜ್ ಇದೆ ಅಷ್ಟೇ. Then you can get that entire policy. That is the only point. Yes. When do you want? Yes, next Thursday. Yes. Yeah, okay. No, if it is a motor vehicle policy, then you need not take notice for owner. Not again. Next you can verify. Otherwise, owner has to be served because other liability will be coming for one. Limit. Yes. Yes. Now suppose how that accident has occurred is sorry. Or there is no other vehicle involved. ಎಲ್ಲ ಕವರ್ ಆಗ್ತದೆ. ಅದರ್ವೈಸ್ ವೈಡರ್ ಲಯಬಿಲಿಟಿ ಈಗ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಆದ್ರೆ ಬರಲ್ಲ ಅವ್ರಿಗೆ. ಅಲ್ಲ ಈವನ್ ಇದು ಬರೋದಿಲ್ಲ ಅವರಿಗೆ, WC ಪಾಲಿಸಿನೂ ಇಲ್ಲ ಅಲ್ಲಿಗೆ. ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಬರುತ್ತೆ. ದಟ್ಸ್ ವಾಟ್ ಕೇಶವ ಪ್ರಶಾಂತ್ ಲಾಸ್ಟ್ ಟೈಮ್. Yes, please. Yes. Yes. Minor ಆ? ಮಲ್ಲಿಕಾರ್ಜುನ್ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಇದು? 40% ಅಂದ್ರೆ 3 ಲಕ್ಷ ಪ್ಲಸ್ 25. ಅದ್ ಕೊಡಿ. ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸಲ್ಲಿ ಏನಿದೆ ಆಪ್ಷನ್? ಮೆಡಿಕಲ್ ಮಾತ್ರ ಎಕ್ಸ್ಟ್ರಾ ಇರ್ಬೇಕನ್ನಪ್ಪ. ಪೈನು ಅಗನಿ ಟುವರ್ಡ್ಸ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 5,000. $375 ಬರ್ತದೆ ಅವ್ರ ಪ್ರಕಾರ. ಡಿಸ್ಕಂಫರ್ಟ್, ಕನ್ವೀನಿಯನ್ಸ್, ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಪೇರೆಂಟ್ಸ್ 25,000, ಮೆಡಿಕಲ್ 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ ಅವ್ರದ್ರಲ್ಲಿ 350, ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅದು ಇದೊಂದು 25, 3,75,000 ಬರುತ್ತೆ. 3,60,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 10,000 ಅಷ್ಟೇ, 15,000. ಎಸ್. Shri Raju Learned Council appearing for the insurance the claimant has contended that due to that extent the claimant has suffered previous injury, the tribunal has assessed whole body disabilities is 14%. 14%. As per the judgment of the apex court in case of Master Mallikarjun, the tribunal, while assessing the compensation, failed to grant any compensation for discomfort, inconvenience, loss of earning to the parents during the period of hospitalization. Hence, he sought for enhancement of compensation. For contra, the Learned Council appearing for insurance company has contended that since the claimant was in a minor, the disability assessed by the tribunal is 14%. The tribunal, after considering that judgment of the apex court in case of Kishan Mallikarjun, Master Mallikarjun, has granted a just and reasonable compensation. Heard the Learned Council for the parties, Perose, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 23/10/2015 due to rash and negligent driving of rider of motorcycle bearing registration number KA42 Q1136. The claimant, after considering the tribunal, after considering the evidence of the parties and evidence of Dr. PW2 has rightly assessed the whole body disabilities is 14%. Since the claimant was in a minor, the apex court, while assessing the compensation in the Master Mallikarjun case, has also granted 25,000 rupees for discomfort, inconvenience, loss of earning to the parents during the period of hospitalization. The tribunal has failed to grant any compensation under that head. Hence, I am of the opinion that the claimant is entitled compensation for 25,000 in addition to that compensation awarded by the tribunal. Accordingly, the appeal is disposed of. Judgment and award passed by the tribunal is modified as follows. The claimant is entitled for the compensation of rupees 3,60,000. In addition, 25,000 with 6% interest.
ಕೆಲವೊಂದು LCR ನೋಡ್ಬೋದು ಯಾರು ಈ ಕೊಟ್ಟ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಲ್ಲ ನೋಡಿ ನಿಂತಿರ್ತಾರೆ ಆ ಬಾಕಿದೆಲ್ಲ LCR ಅಂತ ಇರ್ಬೇಕು ಬೇರೆ ಕೇಸ್ ಒಂದು ಬಿಟ್ಟರೆ ನನ್ನ ಹತ್ರ ಯಾವುದೂ ಇಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ